compensation, I have seen my.
No,
That
I
is
do not know.
that is the determination in before virus. I have seen that.
Oh yes, employees come, but that is for admission of an appeal.
But this has
It has been admitted.
it has been admitted.
Then we don't have only admission.
I'm good.
Yes.
My lord, may I be allowed to be mentioned this matter? This first.
Just wait. Yes.
So this is a matter regarding Order 41, Rule 11. This matter has been settled
Gave
in the past.
to be mentioned. Yes.
Do.
My lord, may I mention this matter for inclusion in the list? This application is for cancellation of the present Okalahoma and engagement of a new advocate on record.
Give the slip. Give the slip. Yes, thank you. It will appear on Monday. You have to move it.
My lord, I am for the petition. Please state it.
All of these are matters.
My lord, I am
Yes,
for the
please.
petitioner, my lord. My lord, this matter already, all of a sudden, my lord, matter was released on.
All of a sudden is not there.
রমজান নির্দেশে ক্রিয়ায় রয়েছে লিখিতের কোটে Last order.
Yes,
My
it has been assigned to us.
yes,
So we have to fix the matter on some day. So let it appear after vacation because
yes, my lord.
hardly there are 4 or 5 days. Yes, the matter has come up by way of an assignment from the Honorable Chief Justice. Let this matter be listed on 5th May, 5th, sorry, 5th January.
This is a matter, where other advocates, state advocates were earlier appearing. Just
It appears to be a PIL, so naturally the state or the Advocate General, whoever,
that advocate is
intimate.
not in the panel. That's why it was we are engaged afresh. Yes.
Whatever, you are representing the state.
Some more time be given, madam.
No, 5th January is far, 3 weeks time nearly. Yes.
May it please your lordships. Lordship, I have
Why to be
minute when
mentioned?
disappearing. My lord, this matter was lastly taken up on 4th of October, where lordships were pleased to direct that affidavits be exchanged by the parties. They had to file their reply within 2 weeks, and we had to file. My lord, we are in December now. We have not received any opposition.
My lord,
And here I am a silent spectator as a father. My lord, there are 2 children involved. The custody is with the mother. I have interim relief prayed for in my application. This is an appeal from an impugned order, my lord, where my application under section 25 of the Guardians and Wards Act was
I'm
rejected.
praying for only one further day, my lord. By Monday, I will be able to file it, my lord. I am the one in default. I am personally responsible, my lord. Kindly allow me one further day.
Lord, there are serious interim reliefs that we had prayed for.
It is a first extension or a second extension?
My lord, first extension I'm praying for only.
Lord, we had mentioned the matter
My learned
several
friends
times
had
between
prayed for
lordship.
stay of the decree, my lord. Lordship was reluctant to grant stay of the decree, had directed affidavits to be exchanged. I'm praying for only one day.
Now the children they need urgent medical attention.
There is no order for stay.
My lord, my
My
learned
lord,
friends
there
had
is no
prayed
order
for a
to stay. We have prayed for shared custody, lordship. My lord, one of the primary grounds of rejection was
I
that
can
we have
demonstrate, my lord, that there is no question of interim shift of custody being granted pending the proceeding under section 25 of the Guardians and
Let
Wards
us
Act.
see, we can make some interim arrangement.
Yes, my lord. Yes, my lord. That is in the utmost need.
The custody may not be
Lordship.
immediately taken away, but there may be some
Interim arrangement is
My
already
lord,
provided for in the decree.
You file it by Monday.
Yes,
You file it by Tuesday, Wednesday, and then we'll fix the matter on Thursday.
Please, my lord.
grateful,
Time to
lordship.
file affidavit in opposition is extended till Monday. Reply, if any, shall be filed by Wednesday. Let this matter list the matter on Thursday.
Very grateful, my
Grateful,
lord.
lordship.
But this has come at my instance for extension of interim order. Interim order has been granted by your lordships. This is the affidavit of service. My understanding is appearing for the
I beg to appear on behalf of the opposite party number 1 and 2 objector, my lord. This, my lord, letter of administration was dismissed on 2 grounds. One limitation point, another
What?
limitation.
but the letter of administration.
After 26 years, the case has been filed without any explanation. My lord knows that explanation is must.
No, absolutely not.
My understanding of law in a probate proceeding is
Initially, also we
no,
our
there
understanding
is
that
no period of limitation provided under the probate.
Court gone considering 130.
No limitation.
but 2019 judgment, my lord.
What to
Nibruti Bhagavat judgment, my lord. Explanation, Honorable Apex Court held that explanation must be there. Why such delay after 26 years?
No. Read that, judge.
Then appeal be heard.
Read that.
But my applicant has been turned down on
There is only one judgment which says limitation will apply, provided
2008 judgment.
right to apply for letters of administration or the probate accrues And if it accrues, and if it does not file, it is not filed within 3 years, then limitation. Otherwise, in a probate or a letter side administration proceeding, no period of limitation.
Here also the
No limitation.
applicant, my lord, did not, my lord, mention when right accrued. Because the
Cannot be. If
1986.
right, the moment he files the application for letters of administration of probate, indicating that the right to accrues. In that judgment, the fact was different.
Here, my lord, my applicant has been turned down on twofold ground. Number one, court considered that whether I am a really adopted son.
adopted son, that
I have not-
cannot be, my lord.
Rather, we have not gone there. Whether the probate court can go into the
Absolutely.
question of title
Yes.
is a
That your
I
lordship
do
has,
not support that ground, my lord.
that your lordship has considered. This is the two ground. One is limitation and this one is the second ground. For
Whether,
that,
my
my
lord,
applicant has been turned down.
Adopted son, no evidence,
So-
I do
so
not support it.
You can argue this matter.
Yes.
Tomorrow also, we can dispose of immediately. First appeal. You have that judgment of 2019, you have a judgment of 2008. Give it. Bring my judgment.
Yes, my lord,
Bring my judgment.
in that event, my lord, only 2 days time is required, my lord. Today is Friday, my lord.
I have already delivered a judgment and distinguishing all the judgments that under what circumstances this principle
Letter
will
of
apply. Sure. Straight away.
And that is-
Limitation can be a ground.
Yes.
That's the only thing.
Only.
Right from Privy Council up to very fairly up to number of judgments, it says no limitation for probate. That I know.
But initially our understanding was that,
Correct
my
me,
lord,
I am ready to
after, my lord,
amend myself.
after
No
the
problem.
apex court judgment, we confused, my lord.
No confusion.
But fact was different. দাদা, ওটা
The
দেখবেন।
fact was that in that Supreme Court judgment, the fact was that there was an application for probate.
Probate.
Later on, they did not proceed with the application. They rather withdrew that application.
And
Then
then,
thereafter, certain proceedings were initiated. The suit was filed by the other side, claiming a undivided right, as if the testator died intestate. The moment they realize that if it is an intestacy succession, then they will not have that much of share. Then a application for probate was taken out, that too after 7 years. When
Right.
that suit ripened for a final judgment.
here also,
Here the Supreme Court says that no, your right to apply probate accrues. And if you sat over your right for more than 3 years, that's a residuary article, then this
Limitation.
application or proceeding would be hit by limitation, not in others.
But only thing, my lord, my understanding is that
here also, my lord, they knew that will is there, executor is there, but did not proceed with the, my lord, case
The will
after 26
of-
years.
Very known, well-known jurist of the time, the will dated 1897. An application was filed in 1940. Grant.
his client was a testator. His client was a
Yes, my lord.
testator. He did
Matter-
not
matter
file
can-
within
matter
time.
Can be disposed of, my lord, only 2 days is required. If your lordship
Others-
only fixed it Wednesday, because Monday I will not be here. my lord.
There is a
There's no
problem.
problem.
I'm telling you, lordship. Although, my lord, it's in my favor, my lord, the judgment, but my lord, the other person who contested in the court below, I don't know from whom.
No. I only appear on behalf of the, my lord, opposite party number 1 and 2. Other,
Then we extend the interim order, come after the petition. Yes. The matter has come up for extension of interim. Interim order was granted on
13th October.
for a limited period. It appears that the
See,
copy
Dada.
of the application has been
Dada.
served upon all the respondents. But respondent number 1, you
and
are
2. 1 and 2.
1 and 2 appears. In view of the above, the interim order granted earlier next year for a period of 10 weeks from date or until further. This application or here is the application 1 week after the reopening of this court.
My affidavit service be kept.
Let the affidavit subscription.
Can you extend?
Great.
Find out my judgment.
Yes, my lord, I shall.
Is it reported or not?
Yes, reported.
Can you give that citation? I don't keep track. Please give that citation. That's simple. More orders better. Let us see the applications because those are
Maybe after the vacation.
not after it.
The hearing matter.
We will be left with no work, my lord. Our experience is this. So let us wait. Let us do. Yes. All applications.
I am the petitioner. This application is, my lord, for substitution in the midst of hearing, my lord.
222.
No. In the midst of hearing of this appeal, my lord, the
Who died?
Respondent number 7, my lord.
7 died.
Respondent number 7.
And my lord, this is affidavit of service, my lord. Service has been effective.
You are appearing for whom?
Respondent number 1 to 6 and 10 and 11, my lord.
And my lord, Mr.
7 died.
7 died.
8 and 9.
8
My
and 9 also they are, my lord, appearing with Mr. Asim Kumar Rai.
7 এর কেউ তো appear করে
7 এর হয়েও appear করেছে। And my lord, he will appear for the substituted
That he is not here. How do we know?
My lord, he told me, anyhow, my lord, kindly fix it, my lord, after allowing application.
allow application
Then you'll have to put in the service. Then we will have to put in the requisite for service.
সব appeal দিতে হবে তো
My lord, I shall intimate him, my lord, if
Don't do, because if he is here and he says, I have instruction, then he can file a Vagalatnama, we can do it. But unless it is,
my lord, he is engaged in another.
sorry, that part,
memorandum of
then allowing, there is no difficulty. When he died,
My lord, died in
9
September.
September. Within time.
yes,
9th September 2023.
9th,
September 23. While on the date when this matter was heard also.
when this application is filed,
My lord, the application has been filed on 5th October 2020. 23.
why nowadays every lawyer is apprehensive of not going before the Lavajima court?
My lord, because of the fact, my lord, this,
Everybody is coming with a substitution
my
application.
lord, so far as,
Then what for the Lavajima
my
court
lord,
is
the
there?
Lojima court, here, my lord, the hearing was continuing, therefore, my lord,
But this is in time application.
therefore, my lord, I prayed before your lordship
left
for
to do
enlisting
work.
the matter and for hearing.
Everything is to be done by the bench.
My lord,
You are a veteran, a seasoned lawyer.
my lord, I know because of the fact this, which will cause delay, therefore, my lord,
All these applications are coming up.
the matter was hard. Therefore, my lord, I am praying, let this application be allowed, my lord, and the
No, that
appeal.
we know it is within time, it cannot be rejected, but why not Lojima?
My lord, the fact remains that, my lord, on the date of hearing, my lord, I told that,
Then we are recording our observation that henceforth no application within time should be listed before the court.
my lord, beg to be excused, my lord, the
We are
fact,
recording this, that this is what is the impression for that it has come, which is not a valid ground. Which is not a valid ground at all because it was not parted, it was not reserved for judgment.
it is an assigned matter, my lord, this was once heard by your lordship.
So what? It was not concluded.
No, my lord, fact remains that this matter has.
Do that. Please let them, they are left with no work.
My lord, kindly excuse me, my lord, henceforth I shall file.
This is an application for substitution of the ASL legal of the respondent number 7, who died intestate on 9 September 2023. In paragraph 2 of the said application, it is the names of the heirs and the legal representatives have been included, have been disclosed. Stop. Since the application is filed within the period of limitation and is in Alada form, we do not find any ground for rejecting the same. Application is allowed. Let the heirs and legal representatives, as shown in paragraph 2 of the said application, be substituted in place and state of respondent number 7 since decease. The office is directed to make a necessary amendment in the memorandum of appeal immediately. The appellant is directed to put in the requisites for effecting service of notice of appeal upon the substituted respondents on or before the closure of this court for Christmas vacation. Office shall ensure that the service is effected immediately.
আমার নামটা দিদি
Yes,
23. 23, I am for the petitioner, my lord. This is the restoration application along with, my lord, section 5, my lord.
Have you served
No, my lord.
service both applications 2 weeks after reopening?
My lord, in this matter, my lord, the direction was there, my lord, upon the manager Punjab National Bank New Goria branch to disclose the details of the pensionary benefit received by the decree holder husband. I am for the wife appellant. Now, my lord, that order was communicated to the branch. Nothing came forward. On, my lord, 10th of October 2023, your lordships were pleased to give a further chance to that bank, not for disclosure. That is in terms of Neha's judgment, your lordship knows. Now, my lord, I have already served. There is the affidavit of service. My lord, unless that report comes forward from the bank, my lord,
Where was the earlier order, last order?
my lord, that is, my lord, order dated 8th of May 2023. My lord, may I hand up a copy of the order? Kindly look at the second paragraph of this order.
Dated
8th of May 2023. My lord, some statements in the affidavit of assent, some statement was given which was not relied upon or believed by the other bench presiding over Justice Sen. Now, my lord, for that matter, this direction was given. Immediately it was communicated. My lord, nothing has come forward till today. Well, in the affidavit, my lord, the husband disclosed that he has no money. The entire benefit, whatever he obtained at the time of retirement, he was spent for repairing of the house. And as of today, his income is 15-60,000 towards pension. And from that meager income, that is also not, my lord, sufficient enough for him to manage himself. which the other bench did not believe or whatever. So
The entire saving of the life will be invested in the repair of the house.
that is what he has stated in the affidavit. What is
Remember,
normally not possible for a person. That is what has been stated. I shall rely upon the affidavit. That is on record. And my lord, it's a two-storied building. And it's a two-storied building, my lord. Series of orders were passed by the other. Blood in a two-storied building, the entire building is enjoyed by the husband, and I am living in a small room below the stair. And blood, I have no independent kitchen nor toilet. So for that, even today, same house, despite the order passed by the other bench, blood, no accommodation has been given. Specific order is there that you provide a room with kitchen and toilet. Initially, he appeared through state legal service authorities. Subsequently, some advocate, some Mr. Beda did appear. If your lordship so desires, I shall have a copy upon him. I don't know why he is not appearing. Initially, it is with legal service authority, but at several occasions, husband did not appear. Court directed, but the legal service authority represented. Subsequently, Mr. Beda appeared in one occasion. The affidavit of assets, what have been served, that has been affirmed by one Mr. Gorachand Samanto, advocate.
He is an advocate on record.
Mr. Beda.
Mr. Purachand.
Mr. Gorachand Samanto is the advocate on record, it appears. I do not know whether he is still appearing, but I shall serve. If your lordship so direct, I shall serve upon him also. But direction was upon the bank.
On 8/5/23, the court directed the manager Punjab National Bank, New Garia branch, Kolkata, file a report disclosing the details of pensionary benefits received by the respondent husband at the time of his retirement, and also any other benefits that he had received over and above at the time of his retirement. The statement was also required to disclose the pension being received after his retirement. The report, the counsel for the appellant has appeared and filed an affidavit of service from which it appears the order was communicated to the branch manager on 18/11/2023. We find, however, that no report is forthcoming in terms of the order passed on 8/5/2023.
Which New Garia is a inspector in charge or the officer in charge?
My lord, I believe officer in charge. It should be officer in charge.
We therefore consider it appropriate and necessary to direct the officer in charge, New Garia Police Station,
New Garia Police Station.
Garia Police Station, to ensure communication of this order and physical appearance of the branch manager on the returnable date, along with the ensuring compliance with the earlier order dated 8/5/2023. The matter is made returnable on Thursday.
Thursday, and communicate this to Mr. Bera or Mr.
Samanto. My lord, I tell you, Lordship, only one thing. My lord, at least on 8 occasions, the matter did appear before they were on bench presided by Justice Sen. Since the husband did not appear, the similar nature of order your lordship is passing today. Similar nature of order was passed directing the officer in charge, Sonarpur police station, to ensure the presence of the husband. Only then the husband did appear. That order is also on record.
Let us see first the bank. Let us see the bank details.
My lord.
Let us see the bank details.
Yes, yes.
What bank manager was
of course,
supposed
your
to
lordship.
divulge, let him.
Of-
Then we'll
My
consider.
lord, speak.
Thursday, we have said.
Oh, my lord, the only
21st.
difficulty is this. My lord, his mother will be operated on 22nd, 21st. But that day he may not come. Any other date, any other.
You are here. We are
Okay,
left
as
with
your
5
lordship.
days.
Yes,
We are
yes.
left with 5 days.
But thing
Not
is
possible.
this, Lord, his mother is the wife of my brother, so I may
Really?
also require to be present in hospital for knee replacement. I may require to be there. But on 20th, kindly fix it on 20th. আমি 20 তারিখে বলে দিচ্ছি 20 তারিখ Lord, kindly fix it on 28th, Lord, instead of 21st. আজকেই কমিউনিকেট করবো একদিন ঠিক করে আজকেই কমিউনিকেট করবো Kindly fix it on 20th or 22nd instead of 20.
22nd is a dicey day for me.
20 in that case, 20th Lord, or 21st.
Can it be ensured within that time? Because you
Right
have to
today, if I get
communicate.
your lordship's order in the server, Lord, right today you shall serve. Right today.
Come on Wednesday.
Wednesday.
এই ওটাকে থার্সডে জায়গায় ওয়েডনেসডে করে দাও।
My lord, I am extremely. আজকেই কমিউনিকেট করবো কপি হ্যাঁ অর্ডার সাহেবকে অর্ডারের বাঞ্চটা সাহেবকে দিলাম আই এম গ্রেট
Yes.
My lord, I beg to appear on behalf of the appellant, my lord, plaintiff, appellant petitioner before your lordship.
I'm for the respondents.
My lord,
Plaintiff appellant,
appellant, my lord, first,
husband.
no, my lord, suit for partition, my lord, between brothers. My lord, I claim that I have, in my suit, my lord, I claim that I have 1/3 share in the suit property. There are 2 defendants. My lord, my suit was dismissed, my lord. Against that, this appeal has been preferred before your lordship.
Why dismiss?
My lord, my contention in the suit was that, my lord, I came to know from my brother that they have, with regard to the suit property, my lord, they have already, behind my back, they have already filed a suit for declaration of title and obtained an ex parte decree. I even,
What declaration?
declaration that they are the owners of that particular,
You are not.
I am not. No, my lord, and on the basis of that, they say that I am not entitled to the share. So that on that basis, my lord, that gives me
What
the,
you did with that decree?
my lord, that decree, my lord, we have pleaded that in this suit that that decree is not binding upon me, and that the vakalatnama that has been filed on my behalf as defendant number, as the defendant contesting, I have not executed that vakalatnama. These were the pleadings in my plaint.
In the subsequent suit.
In the subsequent, in my partition suit.
Did you seek for a declaration that decree is a nullity?
My lord,
Is
the
an
prayers
outcome
I
of-
have seen, and
Not prayer, release have you sought?
the,
Outcome of a fraud or a forgery?
my lord, in so many words, my lord, it's not there. My lord, I have
It
the
is
plaint.
obviously because you have not executed Vakalatnama, somebody fraudulently
That
executed.
that entire pleadings are there, my lord, in my plaint.
Did you ask for a relief in this regard?
In this regard, my lord, I have, yes, my lord, your lordship, kindly, I'm just placing the relevant paragraph of the plaint.
Forget about it. Now, what do you want at this?
My lord, my lord,
application?
my first appeal, let it be, my lord, I have inspected the records that come. My lord,
What you want in the application? What is this application for?
my lord, the application is for injunction, my lord, restraining the parties not to transfer, alienate, my lord, all the parties, my lord. And my lord, your lordship, kindly direct me to prepare the paper book, my lord, and the appeal may be heard, my lord.
And this appeal was filed in 2021.
2000, no, 18.
18. You are without injunction for such a long time.
Well,
What is the
that
necessity
is true, madam.
now?
There is also no averment in the application that Lordship, I am doing anything.
Well, that was a 2018 application, my lord.
Now we can't. We are expediting the appeal. Lower
Lordship.
court record has come or not?
My lord, I'm told, my lord, I can check the record. I'm told that it has come, but inspection has not taken place.
Victim service. Sorry. The lower court record has not arrived.
The record has not arrived.
No.
Well, at the time of mentioning, when I was tracing the file, it was told that. Then, my
I
lord,
do not
it's
know.
my.
At least I do not find.
Then, my lord, I
that
will be putting the special messenger cost, my lord, before this side of the vacation.
thing, you know. LCR is not there. You are
I am
appealing for.
appearing for both the respondents, Lordship. Wakalatnama was filed by Miss P.
No,
Das.
that we find there is an endorsement ready as regards service.
Yes.
But what about lower court record? It has not arrived as yet.
Then, my lord, I will be putting the special messenger cost, my lord, by Tuesday or Wednesday.
This is an application for injunction restraining the respondents from creating any third-party interest and or alienating, transferring and or encumbering the same during the pendency of an appeal. The instant appeal was filed as far back as in the year 2018, and the application remained pending as no ad interim order was passed therein. There is no averment that any such attempt is made by the respondents with regard to the alienation and or encumbrance of encumbering the said property. Stop. We find that the appeal is otherwise ready as the service of notice of appeal has been effected upon the respondents who is represented before us. We thus do not find either a prima facie case or a balance of convenience and inconvenience and irreparable loss and injury to be caused to the petitioner, and therefore the cost to the petitioner, full stop. However, we feel that if the appeal is otherwise expedited and heard on a priority basis, it would subserve the justice. Accordingly, the application is disposed of, directing the appellant to put in the special messenger costs within
Tuesday.
Within date or Tuesday.
19.
Stop. On deposit of the special messenger costs, the official ensure that the lower court record reaches to this court in the month of January 2024. Then, after arrival, examination found complete, notice under order under Rule 12 of Chapter 9 upon the advocate and record of the applicant. Preparation of paper book 4 weeks from the date of service of notice of arrival of liberty to mention.
We have submitted the Talabana, my lord.
That is
And
for the purpose of
Right,
effecting service.
And my lord, liberty may be given if situation so arise, my lord, I can file, take out application for injunction, my lord.
That is in the changed circumstances. So it
My lord,
does
that
not
liberty
require
may be-
any liberty. How
Because
can we foresee that
if
there will-
situation so arise, my lord, that
we can't.
I can make out a case
on
that-
a presupposition, can a court grant a liberty? There is no element.
If situation so arise, then my lord, I am
That right is within your, within the
Civil
provision of law. If there is a change circumstances, then definitely.
much.
Grateful of.
Appellate petitioner, Lord, your lordship directed me to serve the application for injunction in connection with the first miscellaneous appeal. But in spite of best effort, it could not be served. We have addressed it to the address given in the plaint filed by the opposite party. But it has come back with the endorsement. কেউ বলতে পারছেন না. Nobody is in a position to say the whereabouts. And it has come back.
His whereabouts. Nobody booked it.
Lord,
What to do?
your lordship, kindly direct to
What is
serve
the-
upon the learned advocate in the court.
No, court below means any execution case pending or something.
No execution or ex parte degree has been set aside. Thereafter, Lord, during on the
But
basis
the suit,
suit has been restored.
then what is happening? in the
Lord,
suit?
thereafter, after on the basis of ex parte degree, we are dispossessed. We filed an application under section 141. That has been
Suit
rejected.
is pending.
Suit is pending.
The suit is not proceeded with.
Suit is pending. This order was refused. Thereafter, we approached this honorable court.
So they contested in the suit.
Lord, they are plaintiffs.
Correct.
Yes,
So-
yes.
So they contested this.
Yes, yes,
So serve the copy.
yes. Have the copy upon the learned advocate in the court below. Yes. Lord, in the same address we have sent in the plaint address, but it has come back.
But you'll have to file an affidavit of service.
Lord, your lordship,
So how can
Lord,
you pass an order?
Lord, your lordship, kindly then. In course of this day, I am filing the affidavit of service, saying all these things. In course of this day.
That this cannot be done in this way. Commit to file it.
Yes.
Keep it ready and then give it.
Yes.
We are passing an order, but that will be subject to your filing of.
Yes,
the
yes, yes, Lord.
Lago. The Mr. Ghosh, the learned advocate appearing for the appellant submits that in terms of the earlier order, the copy of the application was sent to the plaintiff's respondent to registered post, but the postal article returned with the postal remark. Nobody was able to disclose the whereabouts. He submits that the postal article was sent to an address which the plaintiff respondent disclosed in a plaint filed before the trial court, and therefore such endorsement indicates that they are avoiding the service.
Yes.
Our attention is drawn to the fact that the ex parte decree passed by the trial court was subsequently set aside by the competent court, and the suit was restored, but the appellant was dispossessed on the strength of a set ex parte decree. Stop. The appellant filed an application for restitution of possession, but the trial court dismissed the same. It appears from the aforesaid statement that the suit is pending, and the said application under section 144 of the Code of Civil Procedure was resisted by the plaintiff respondent. Stop. In order to obviate any complication, we therefore direct the appellant to serve a copy of the application upon the learned advocate representing the plaintiff respondent in the said suit, indicating that this application shall be listed 1 week after the reopening of this court following the specification, and shall file the affidavit of service on the returnable date. This order will be signed only when you file.
Yes. Yes.
May it please the Lord. This is my appeal, my Lord, in respect of encroachment upon my plot of land.
In respect
In-
of
Encroachment upon my plot of land, my Lord, by my adjacent neighbor, and my Lord attempted construction there. No, my Lordship was pleased to pass an interim order on the last occasion, 12th October 2023. Lordship is pleased to, Milord, the operative portion above the above, Lordship is pleased to give me an interim protection for 4 weeks. And in the meantime, service is completed upon the dependent.
The service is complete.
Yes. Service is complete, Milord, upon the dependent. Hard to copy. Duto copy. There is a sole dependent, Milord. Service is complete. You restrain from making, Milord, any further construction over and above my plot of land at Milord 543 GT Road, Howrah.
So nobody has communicated to you that he is appearing for the respondent.
Milord, service করেছি.
Anybody communicated to you, any lawyer that he?
No, Milord, no communication has been received.
You have not received?
No communication has been received. And it was personally served on the defendant, Ram Ratan Chaudhary. Personally served on the defendant.
They-
On an application filed by the appellant, this court had directed for service upon the respondent while passing an ex parte ad interim order against the restraining the defendant respondent from making any further construction upon the municipal holding number 543 on GT Road within brackets south for a period of 10 weeks or until further orders. Stop. The affidavit of service has been filed showing service of notice upon the respondent on 17/10/2023. There, however, is no appearance on behalf of the respondent. In these circumstances, we deem it appropriate to make the ad interim order absolute till further, till the disposal of the appeal. The petition is disposed of. Application stands disposed of.
Much. Milord, may file, Milord, paper book out of court, Milord, within a period to be fixed by a lordship.
It's an FMAT.
Yes, FMAT.
Right.
Lordship kindly grants me the liberty, Milord, to file the paper book out of court.
A appellant to prepare an informal 8 copies of informal paper book. ঠিক আছে? In FMAT. Within 4 weeks after reopening.
4 weeks after reopening.
At last করে দাও, let this order be communicated to the respondents by speed post so that they may also.
Much.
LCR লাগবে না FMAT. এটা injunction.
Much.
Not in 228.
Lord, in item number 228, Mr. Shonak Bhattacharya is appearing on behalf of the petitioner. He is on his legs in courtroom number 19. I am praying for a short pass on.
Applications, what is this
My
application?
Lord, it's for withdrawing the sum which I have deposited before the learned registrar general.
So why don't you move it? These are the matters where the juniors should move. Appeal has been dismissed or
Yes, my Lord,
so,
appeal has been-
so and there was a deposit.
Yes, my Lord, there was a
So you
deposit.
wanted to withdraw.
Yes, my
So
Lord.
it's not a junior who will move it.
My Lord.
Pass over. Then after vacation, if you are so interested after vacation.
Lord, kindly, my Lord, short.
No, why? These juniors, why are you not there in the brief?
Yes, my Lord, I was.
Then will you not read? Will you not say the facts? There's no law point involved.
No, my Lord.
It's only the facts which is involved. Will you not? I can understand the junior will learn law by a passage of time, gradually. But at least he must master the fact. Will you not read the fact? Come at 2 and do. Read by this time.
My lord, I am filing supplementary affidavit as per your lordship. Grant me leave to file the affidavit. Sir, my annexure was not proper.
Yes.
Lord, we are appearing for the respondent, my lord, for the referring claimants. We are led by Mr. Awan
It's
Banerjee in
for
the
the
matter.
state. This is
State
against
is
acquisition
the
proceeding.
appellant.
Land acquisition proceeding.
Yes, my lord.
How much? What do you want by this application?
Application
Stay of the execution or what?
extension of time to deposit the digital amount.
You have not deposited.
Time we cannot.
What was the time granted?
4 weeks.
When that order was passed?
11/5/2023.
11th May.
11th?
May.
11th May.
11th May. Within what time the decretal amount should be deposited?
Annexure in
11th May 2023.
11th May 2023.
4 weeks.
So it expires in the month of June. What you will do in the June, July, August, September, October, November.
Now the money is
Now
available.
December.
Now the money is
11th.
available. Now the money is available, so I am praying for extension of time.
Very good. With certain costs for delay. Further.
My lord, the next day is fixed on 6th of January 2024.
This is the first appeal. It's a matter of right. The only thing is, since it is a money decree, we cannot grant a blanket stay. They have to put on terms. So the court, while disposing of, has put them on terms. They have to deposit. So now they have come up. What you were doing? The state is the most solvent
No, department
entity.
Until unless department is coming to us.
What department?
Their communication has been made.
The department is under the government or the government is under the department? Tell me.
According to my instruction, according to my instruction, my lord, I have made application.
Then instruction, let them pay. What is the total amount, decretal amount?
My lord, as per their calculation, my lord, 75,99,394.
So you pay another 20,000 rupees a cost for extension. Because we do not find it is so sufficient. So many. When you take out an application?
Application made on 24th August.
So it expires in June. What you were doing in June, July, and then August also 3 months. What you were doing? 11th May, then 11th June, it expires. then 11th July, August. What you were doing?
Kindly see the page 10, my lord, the supplementary APD. Page 10 of application. Page 10 of application is the communication, departmental communication.
Yes. What is that communication? Please take it.
DM collector Hooghly, office of the DM collector Hooghly, July 4th July 23rd.
When that order was communicated to him?
In the server, my lord.
Server, it must have been there, server, immediately within 2 days. I don't believe that bench will take 4 weeks time or a 5 weeks time to upload the order. And secondly, the order must have been dictated in the open court. So you have taken note. You know what order has been passed.
An order was dictated in open court, not pronounced later. But so far as deposit, my lord, I leave it to your lordship because the respondent, they are suffering. My lord, if the deposit, we shall make an application for withdrawal of a portion of it. My lord. They are, my lord, in a precarious condition. 2011 notification. Then it went on. So it was a stay in the Honorable High Court. Ultimately, my lord, the new act came in. Then they calculated. Then reference. So for a long time, it is going on. If you lord, I leave it to a lordship. Not taking deposit. Execution is also fixed on just not on reopening. December, January. I leave 6 January.
How much cost?
As per your lordship's deduction, I shall do the same.
And how soon you will deposit? Tell us.
Within a week. Within a week. Hating of digital dues in connection with.
So you can deposit with by Friday, this Friday?
ডিপার্টমেন্টের লোক করেছে ডিপার্টমেন্ট তো করবে আমি করবো নাকি টাকাটা না দিলে আমি পকেট থেকে দেবো
You are not sure. Then what for you are appearing for the appellant? We are asking you and you are unable to say. You say the money is ready. Can you not deposit by Friday?
My health is not well, my lord.
Yes.
My health is not well. I have not come. Only today I have come.
Sorry? You must have a consultation with the department. You said, argues that now money is ready.
And according to annexure. আমার শরীর খারাপ আমাকে করতে লাগছে বলো তুমি বলো স্যার শরীরটা ভালো লাগছে আমি তো আসিনি আজকে এসেছি আমি তো আজকে এসেছি শরীর খারাপ ছিল না আমার তুমি অ্যাকসেপ্ট নিতে পারবে উইদিন a week he said within a week he talked with the department
By next Friday, you can deposit.
And what about cost?
Can consider, madam.
Yes.
Kindly consider that as well, madam.
Well, this is really a cost for a cost.
Lady aged 65 years, husband has retired.
We have communicated the malad. It's page 10 of my application, malad. We have communicated 4th of July. Yes,
July. This was sanctioned.
This was not sanctioned.
What prompted you not to immediately take out an application? You took out on 24th of August.
4th of July were not.
That shows, and thereafter the matter is pending. You ought to have, when you know that the office is taking longer time and the time is ticking up, you should have made an application immediately before the expiration of the period, seeking an extension. You waited for such a long time. You should have that there is some departmental procedural hassles which is really impeding in depositing. Please extend the time.
Sorry. Some lachin is there.
That was not done. And after such a long time, when it expires in the month of June, 11 June, then 11 July, 11th August, nearly 2.5 months thereafter, you are filing an application seeking extension. So you must pay a cost. That bona fide is not apparent. You do not find that your conduct is so bona fide. The land acquisition matter, he has lost his land, yet he is not in, he has not received the appropriate and reasonable and the just amount. So let them pay some cost. Let them pay. They will realize. And if you say we can say that because of the delay, the cost has been done, misconduct. We are giving the liberty to the government to fix the responsibility and can realize that amount of cost from that hearing officer. Let it. The government will fix the responsibility, who was responsible, and then realize from the salary or whatever. The government will realize this cost amount. That will do.
If you would mention all this in minimum cost.
There is no difficulty. After all, the government exchequer is burdened. So the officer who has been in helm of the affair, who is responsible, fix the responsibility, recover from it. What? Do it. That is within your. You have to make an inquiry and fix the responsibility. Not the easy way that you are a government, as and when you wish, leases will come and the court will pass an order. You are not a privileged litigant. This is an expression used by the Supreme Court. Order dated 11th May 2023. An application for stay of the execution proceeding was disposed of, directing the appellant to deposit the decretal amount with the Registrar General of this court. It's within 4 weeks. Within 4 weeks from date. A further direction was passed upon the learned Registrar General to invest the said amount in an interest bearing fixed deposit in any nationalized bank and continue to renew the same until further on. The instant application is taken up seeking extension of time to deposit the decretal amount as directed by the coordinate bench on 11th May 2023. The application is taken out on 24th August 2023, which contained a letter at page 10 that this amount of rupees 75 lakhs and odd.
93 lakhs. 93 lakhs.
It should be 93, but by mistake.
93 lakhs and odd. Yes. Had been sanctioned and lying in the custody of the district magistrate of the concerned district. Is it? Yes. There is apparent. No, it is apparent from the conduct of the appellant that despite a time limit fixed for deposit of the said decretal amount, the sanction appears to have been granted on 4th July 2023, much beyond the expiration of the period limited by the order dated 11th May 2023. Is it correct? The dormant and lethargic conduct is imminent, apparent and evident from the conduct of the concerned department. There is no explanation which we could see from the said application, except the procedural hazards and the waiting and or approval from the different departments/officers. The immobility in the government department is not unknown, as the file takes several days or months to travel from one desk to another. It is not my words, this is the word of Justice A.M. Bhattacharya. I'm just recapitulating. The right of a person who loses his land on the by the acquisition proceeding is being postponed and or delayed because of such dormant attitude of the government officers. Be that as it may, it is a concerned department or the higher officer who have to take a baton and ponder upon and interest in and ponder upon the same. But if we do not extend the time, it would defeat the defeat the right of the appellant to have a revisitation of the judgment impugned therein. Stop. In such view of the matter, the time to deposit, as directed by an order dated 11th May 2023, is extended till 22nd December 2023. In the event the said deposit is made within the time so limited, the London Registrar General shall take all possible steps as directed by the coordinate bench on 11th May 2023. The application is closed. What more sermonization than this? Position of cost.
No, I will leave it to your lordship. You cannot pay for it, Lord. It's up to your lordship.
You were looking at it regarding he omitted to impose cost. That is what I said. What more?
The discretionary relief.
Enough.
No, regarding withdrawal, I'll come up after the deposit, Lord.
This is what is we can't give you.
My lord. Unless it is
And
deposit.
come with my judgment also.
My lord. Bangalore Development Authority, your lordship.
I do not remember those names.
My lord.
I know the principles. Sitting with now the chief justice.
Yes, that judgment we brought. After that, one matter was taken up by your lordship in Bangalore Development Authority versus state. In that, Lord, your lordship passed an order and allowed the withdrawal. I shall come back. Come back. I shall come back. Much obliged.
But may I
But
find
I
the,
will send the confirmation.
but may I find the supplementary leave as per your lordship's leave, my lord? But there is some mistake in the annexure in my application. It is also granted leave by.
Then the supplementary affidavit by today we can talk.
Great.
এটা আমাদের কপিগুলো দিয়ে দিচ্ছি
Same matter, my lord.
অ্যামাউন্ট উইল বি চেঞ্জ অ্যামাউন্টটা দেখে নাও কত আছে
Similar matter. Similar. Yes, the amount is not 75 lakhs, 99,394. 75 lakh.
4th July.
Yes, sorry. Date is 4th July.
Order dated 11th May.
Yes, 11th May 2020.
Sure.
Yes. Only matter the amount is different.
75 lakhs.
99.
We have said 93 lakhs and not in that judgment.
Yes,
it should be 75 lakhs and not. Yes.
Great, lords.
আগেরটাই 93 lakhs ছিল এখানে 75 lakhs
Great, lords.
Discuss the next one.
Well, I am applicant petitioner. A copy of the application was sent for service, but the defendant neither contested the suit decided by the court below. It was her ex parte and dismissed, and therefore, my lord, the appeal has been filed, and pursuant to the earlier determination, a copy of the application was to be served upon the defendant respondent. I served it, but he's not received, has not received.
What is the postal remark?
SEC not returned to sender. Addressee not.
Addressee moved.
Addressee moved.
Return to sender.
Addressee moved, return to sender.
So he is not there. He has already moved from there. Oh. What is this application?
No, application for injunction. Because my lord, is a suit for specific performance of contract. My suit land is of 8 decimals. It was sold at rupees 1,70,000, received the money and give possession to my client. My client is in possession and my client got his name recorded in the record of rights. But he is still enjoying. But the deed has not been executed. That is the difficulty.
Why the suit was dismissed? Ex parte?
Sir, he did not contest.
No. Why the suit filed by you for specific performance?
Because the registration was not.
Why it was dismissed? Your suit was dismissed.
Suit was dismissed.
Ex parte state. Why? I'm asking this.
Learned court did not believe that the defendant was the owner of the plot of land.
What?
That is the finding of the court below.
He did not believe that he is the owner. The suit for specific performance.
I have
oral agreement.
oral agreement, possession.
This is oral agreement. Say that. I was just wondering.
No, not followed by any other agreement. But he
did you prove the payment of money? Did you prove any receipt received?
Yes, ma'am.
Something can be deciphered there from.
Affidavit affirmed by him accepting the money. He declared he has received the money. Yes. Money receipt has been given.
Money receipt in respect of a sale.
Yes, madam. Possession handed over. I am in possession. I am enjoying the property.
Recorded. My name has been recorded.
My name has been recorded in the record of rights. Still then, land court will disbelieve the ownership of the land.
What injunction you want?
My lord.
What injunction you want?
So that he may transfer any other, taking advantage of non-registered registration of the sale, my lord, may not transfer the land to. My lord, I have stated in application of your lordship, can you see? Huh?
Which paragraph you have stated?
Paragraph 17 of the application.
17. What you have stated?
I have stated, my lord, unless the respondent is restrained by no jurisdiction from selling, mortgaging, transferring the constitutional property in any way, and from creating any third-party interest over the constitutional
statement that he is attempting. That is the prayer that unless he is. Where is a statement that he is attempting or he is showing the property to somebody, some third party, affidavit, nothing.
One affidavit regarding the लगा नहीं तो लगा था तो पढ़ा तो मुझे तो हाँ
সাপোর্টের অ্যাফিডেভিট দেবো অ্যাফিডেভিট বলে দি
কি বলে দেখে নেই হচ্ছে may I file a supplementary affidavit regarding my possession and apprehension of the transferring of land.
Can an injunction be granted on that?
Because I am in possession, your loss kindly record is in my name. I am in possession of the property.
We are not
He
saying-
received the money. He has confirmed that by executed affidavit. They have received the money, entire money.
Then what is the necessity of three golden principles to be incorporated for injunction? First is the prima facie case. What does it mean? Because if you say your name has been recorded in ROR, if you say you are in possession, that means immediately the court should grant an injunction.
No.
Must be
No.
something.
But he has also affirmed an affidavit confirming.
Attempt in support of the injunction, something has to be done, some affirmation.
But I am interested to get the deed registered.
We are expediting the appeal, you file a requisites, no injunction then is required. You are
But yes, can be
that
matter.
getting the appeal.
Yes, no. Then
Yes, better. So,
no,
we are- yes, we are dismissing the appeal.
status quo be maintained.
What status quo? You
Other-
are not,
But
sorry, you are not asking for.
I have come before Lordship with a prayer for stay injunction restraining the defendant from creating a third party interest. I have a prima facie case.
Correct. So what is the meaning of the prima facie case?
Prima facie case because I am in possession.
Is it a prima facie case?
Number one. Number two, I have paid the money. He has received the money.
Is it a prima facie case? For injunction. What is a prima facie case?
The prima facie case,
Case is that I am in possession, I am enjoying the property, but he is attempting to transfer the property. He came to the property, was showing the property to a third party, and therefore
there is no such threat.
Yeah.
There is no such threat.
then no injunction.
That I can assure you, I can.
Then no. Then what is a? We are on apprehension that I am in possession. That will not do.
But if by this time, if he creates a third party interest, then I will do that.
But he's not attempting.
It's not
not
attempted.
okay.
Not attempted.
So,
Not
no
attempted.
injunction.
Then if your loss kindly claim in position, if the occasions arises, kindly give me liberty, my lord.
No, that your right is there in the statute.
My appeal, I cannot make a better case.
On mere apprehension without any element of threat, can you ask for an injunction? I am simply asking you this question.
Then let me come with a supplementary affidavit.
You said you are not, we are expediting the hearing of the appeal.
That will take time. I will sue.
Yes.
I will be in difficulty then, madam.
Only said that you are not, you are.
Your lordship kindly give me liberty to file a supplementary affidavit, come back, madam. Otherwise, I will be in difficulty. I will be in difficulty. Boldly. Let me come with supplementary affidavit, madam. Yes, kind.
He was granted to file supplementary affidavit within 1 week after the reopening of the school.
My lord.
Get the matter listed again. Or list the matter again. For the next.
Stop it for them. It keeps on.
Opposite party respondent, my friend has handed over the copy of the just.
This is
Not today.
supplementary affidavit filed to the capital.
Not today, we are making it. File it on the next. You have served the copy just now. So he wanted to peruse it. At least he is entitled to look at it. So we are simply making not today. Come on Monday, let us see. We are taking application on each day. Don't worry.
Because the only thing I don't like this lawsuit now. The applications were filed. The 17 it died of 2017 and the appeal of 2020, 2018. Before filing of the appeal, this is expired. But the substitution, these parties sought to be substituted. They died in 2017, 2018.
Not the judgment of the Supreme Court.
What happened actually?
What happened? No. Have you brought the judgment of the Supreme Court? 2000, volume 8 or 9 SCC? Either 8 or 9. Have you brought that judgment?
No, my lord.
And subsequent judgment in your favor of Justice Shubhra Kumar Mukherjee is sitting there.
Other methods are to be adopted.
So both, we are giving you a judgment, come with that. That judgment is in your favor and that judgment is in your favor, come. Find out, we are coming back.
Get close.
May please watch. Section 5 is there, my lord, for limit.
Sir?
No, my lord. I have submitted anything.
Have you served or not?
No.
Service. First you do service and then come back.
My lord.
Yes, service.
Get,
1 week after vacation.
get to lodge. Get to lodge. I will start. In the meantime, and I'm going to get to lodge.
34, my lord, I am appearing for the appellant petition.
I am for the respondent opposite party.
My lord, defendant number 1 in a suit for cancellation, defendant number 1 in a suit for cancellation of a registered partition deed and also paying for fresh partition is the appellant before your lordship. The appeal is arising against an order of allowing the order of injunction in favor of the plaintiff respondent number 1 and 2.
Did not get it.
The appeal is arising against an order allowing against an order of injunction passed in favor of the plaintiff respondent number 1 and 2, my lord. Injunction in the nature that is number 1, restraining the order of status quo order was passed in favor of the parties, my lord. Number 2, restraining the respondent, the appellant, from constructing any new construction on the base portion of the suit property. Number 3, for installing any iron gate in front of the staircase. And number 4, my lord, from restraining also me from using the staircase.
What is this application?
Yes, my lord.
What is this application?
This is the application for stay, my lord.
Do one thing, file your opposition, reply and appeal and applications to be heard together.
Yes, my lord.
Yes.
Therefore, compilation, if necessary, my lord, it can be.
You put it in your opposition, sir, everything, don't worry. So we can dispose of, this is small one. Yes. You are representing the plaintiffs.
1 and 2. They are the contesting. Hearing on behalf of
All the plaintiffs are here. The plaintiffs respondent are directed to file affidavit in opposition to the instant application within 1 week after the reopening of this court following the application. Reply, if any, shall be filed a week thereafter. Let the appeal and application be listed 2 weeks after the reopening of the court following this.
Thank you, my lord. I am of the appellant wife, my lord.
Matrimonial
application, my lord. Last occasion, my lord was pleased to condone the delay
36, my lord, I am, for the respondent, I am holding the brief of Mr. Uttiyur Roy. Respondent caveator, my lord.
Yes.
There's,
Who is
Yeah.
for the appellant? Mr. Shibendranath Chattopadhyay, Mr. Sankit
Sankit
Chandra, and Mr. Amitabh Chakraborty. Where are they?
my lord, I don't.
It is their application.
Yes, my lord.
So
Their application for stay of preliminary decree, my lord.
where are they? And let it go out of place and after vacation.
My lord.
None appears in support of the application. Stop. Let this application be listed after Christmas vacation.
Grateful to your lord.
Lordship, I am for the appellant petition.
What is this two applications?
One application, Lordship.
Can one, can two,
No, 1, 2 has been disposed of. Substitution within time that has been allowed.
and can two?
Can 2 is the substitution application.
Can
Can
one-
1 is the injunction application, Lordship.
এই যখন ক্যান টু ডিসপোজড অফ হয়ে গেছে তখন কেন এটা লিস্টে আছে? সিআই সিস্টেমে ডিসপোজড অফ অ্যাপ্লিকেশন আসবে?
Lordship, the plaintiff is the
Disposed of application. Because that shows that it is still pending.
Lordship, the plaintiff is the petitioner before your Lordship. I filed a suit for specific performance of contract and in alternative return of my earnest money, Lordship. Now, Lordship, one of the defendants appeared and filed an Order 7 Rule 11, Lordship. My plaint has been rejected. On the ground, Lordship, that in my vendor's deed, there was a specific clause that he cannot sell the property.
So the alpha has gone against you.
Yes, but Lordship, in alternative, Lordship, I prayed for return of money. That has not been considered. And Lordship, during the suit, I was enjoying and
Where is beta? Where is gamma?
Lordship will kindly see my plaint. My plaint
Yes,
starts
where
at
is
page
that?
10.
Oh, the omega is here. Beta is not there.
Page 10, Lordship. And my prayer.
Maintainability on the ground of maintainability, this has been,
Yes, Lordship.
they have decided a preliminary issue.
Yes.
Was it framed by the court before
Yes, Lordship. That's ওখানে order গুলো আছে। Yes, Lordship, it was there. Lordship will kindly see my memorandum of appeal in the impugned order, Lordship, page 2. Whether the suit.
why he says that a suit to enforce the agreement for sale is not maintainable?
Because Lordship, in my vendor's deed.
This clause 7 of the.
Yes, Lordship will kindly see, I have annexed that deed, Lordship.
Yes.
That is at page 27, Lordship. That is paragraph 7. This is my vendor's deed, Lordship. Notwithstanding anything contained herein, the lessee have no right whatsoever and shall not transfer, alienate, let out, or part with the possession of the said holding or any part thereof. In spite of that, Lordship.
Is in relation to what? Salt Lake?
No, Lordship.
Then Kalyani?
Lordship, Bardwan, Lordship, Faridpur.
Why lesser? Lesser is the government?
Yes. Lordship. The deed is at page 25, Lordship.
So there was a complete embargo in the.
Yes, Lordship.
That he cannot.
And Lordship, this defendant number 2 who has raised this objection, subsequent to my deed, my vendor has sold it to him.
What?
Yes, Lordship. That is my pleading, Lordship.
He claimed his right on the basis thereof.
No, he is here a defendant only. But at his application, Lordship, my suit went.
And he is a subsequent purchaser.
Lordship.
Without any permission or anything was there in the clause that.
No, Lordship, as per my vendor's deed, nothing can be done. Even permission cannot be sought, Lordship. That I have annexed.
What do you want now?
Now, Lordship, injunction. I was enjoying an ex parte ad interim order of injunction of status quo regarding right title, interest, and possession.
Right title and interest that you can't.
Possession, at least, Lordship, and not to change nature
Title
and
did
character.
not pass.
Yes.
Section 54 of the Transfer Property Act is
But
against.
Lordship, at least my possession be protected, Lordship.
Now possession after agreement of
Sell, Lordship.
when?
2018.
Can you
Lordship, I was enjoying. Let me serve, and in the meantime, Lordship,
can
let
you
us.
protect the possession?
Lordship, in view of that 17A.
1A. 17(1)(a).
But Lordship, I was
To
enjoying.
obtain by part performance of an agreement,
Lordship.
it is definitely not a registered agreement. So, can you protect?
Lordship, let me serve, and in the meantime, Lordship, some protection.
What protection? Tell us. Possession we can't protect. Embargo in the law.
Lordship, they are trying to. Then Lordship, not to sell and nature and character at least.
That has already been sold to defendant number 2.
But we are in possession.
So what?
Lordship, I have specifically pleaded that now he is trying to disturb my possession and trying to change the nature and character, Lordship.
Contradictory, mutually destructive.
No, there are some vacant land, Lordship, beside, because the property he sold to me was structure plus some land, Lordship. There now, Lordship,
You are
they
in
are trying.
possession. If you are
Yes.
in possession of
I am
the
in possession of the
structure-
structure. But regarding the vacant land, they are trying to, Lordship, erect walls and something like that.
how can you, then your possession is not there. in the-
Regarding structure, it is there.
So part, when you are possession of a part of the property, not the whole.
No, Lordship, like that.
So serve the copy and come back and let us see.
And Lordship, let the main matter be heard out then, Lordship.
We'll hear out. This is a small point.
Yes, yes, that's fine.
Service 1 week after vacation. Do you know the order?
Have you evicted it?
Lordship 238, Mr. Shobhan Majumdar appearing behalf of the respondent, Lordship. His mother is ill, that's why he is out of station, Lordship. I am praying only not today, Lordship.
Let us come on Monday.
Tomorrow.
Lord.
I mean Monday.
Monday.
Lordship.
Not today.
Much obliged.
কি নামটা ওর কাছ থেকে নিয়ে নিই কোন ঘরে বসে কি হয়েছে ফোন নাম্বার
My lord, in 239, I am for the appellant plaintiff, my lord. My lord, there is an application for condemnation of delay. My lord, the impugned judgment, I have been aggrieved with the impugned judgment passed by the learned second senior division civil judge Tushura.
How many days delay?
My
Have you
lord-
served the copy or not? Serve. Come back. 1 week
My lord,
after
one-
vacation.
My lord, one humble has permitted to serve the copy of the appeal, memo of appeal on
Application for condemnation.
Lordship 40, I am here on behalf of the petitioner. Kindly grant us time to serve the copy to the other side.
What is this application? What is this application?
Lordship,
Condonation or what?
Well, Lordship, I am led by Advocate Sanjay Mukherjee. He is seriously ill, couldn't make it to the court on this very day. The brief of this matter is also
Service 1 week after vacation.
deeply obliged.
Give your name. Only your name.
241, my lord, I'm for the appellant plaintiff. Essentially, this matter, the suit was for declaration and injunction. It was on a marriage by basically the defendant number one is the erstwhile wife of the plaintiff number one. Now, the erstwhile wife of the plaintiff number one later claimed that post their divorce, the plaintiff number one had remarried the defendant number one, which the plaintiff number one strongly denies and had filed suit.
No. I could not. Can you repeat?
Plaintiff number one was earlier married to defendant number one. They underwent a
Number
divorce.
one. Who is
Yes.
the plaintiff number two?
The second wife of the plaintiff number one.
So plaintiff number one was married to the defendant number one.
And they underwent a divorce, post which the plaintiff one married plaintiff number two.
No.
Now the defendant number one later claimed to the employer of the plaintiff number one and produced a fake marriage certificate to say that the plaintiff number one post the divorce had remarried the defendant number one and had filed a complaint of bigamy against the plaintiff number one as well. Now the suit was filed for declaration.
Cancellation of that certificate.
Absolutely, my lord.
So,
Now the defendant number one, although first appeared in the suit, later did not. The suit was made ex parte against the defendants. Ex parte suit was later dismissed by the learned trial court. We have moved in appeal against the dismissal of the suit.
then
And
who is the defendant number two?
defendant number two is the marriage registrar. The marriage registrar who had signed off on the
Who is the
marriage
defendant
certificate.
number three?
Defendant number three is a ex-judicial officer who's also acted as a legal advisor for the defendant number one and had interacted with the plaintiff number one in such capacity.
So legal advisor is also made a party.
Yes, my lord, I was not dealing with the suit. I would not have made him a party, but he apparently made some threats to such effect.
Whether written statement was filed.
No written statements was filed. Apart from an initial appearance, nothing else was ever. No steps were undertaken by any of the dependents.
What application you have taken?
My lord, I have asked for certain injunctions which were granted, which were earlier being enjoyed by the plaintiff.
What?
It's on page 30, press D to H. My lord, injunction restraining the defendant number one from claiming to be the wife of the plaintiff number one. Injunction restraining the defendant number one from.
How can this order be passed? Because your suit is dismissed.
Well, I'm asking for these injunctions because.
How can it be?
These protections were in place prior to the dismissal.
I do not know. If this protection was there, then what remained?
The suit was dismissed later, my lord. That's the thing.
Sir, the marriage certificate has not been declared null and void, a forged one, fabricated one, whatever.
Yes, my lord. That was
then on
the
the
purpose
basis
of the
of
suit.
that certificate, we will injunct them from claiming your wife. What are you talking about? Your suit got dismissed. You could not prove it.
My lord, the point is I placed all the evidence. The reasoning adopted by the learned trial judge is what is being challenged in the appeal, my lord. The learned trial judge has undertaken specious reasoning in order to support the conclusion that this suit deserves to be dismissed.
Decided in the appeal.
That is, my lord, but till such time as the appeal is.
Whether it is a specious reasoning or it is a valid reasons.
Of course, your lordship.
This juncture, how can you say because you lost? Now, these are the chain circumstances. At that point of time, the suit was not dismissed.
Absolutely, my lord.
So the court might, on that basis, granted you. But now, when the suit is dismissed, then what remains? That means the certificate remains there, staring at your face.
Yes, my lord.
Till the appellate court, in this appeal, it is.
Yes, my lord. That's precisely why I'm seeking this
Then
protection.
what is the next injunction?
My lord, the next is using the certificate from entering into the workplace of the plaintiff number one and two and spreading nasty, vulgar, and defamatory statements to assassinate character. Injunction restraining the defendant number three from issuing threats of exercising his power and connections against plaintiff number one, intending at causing harm to the plaintiff number one.
What she is doing?
Defendant number three is making threats towards the plaintiff of taking off.
Defendant number three is a legal advisor.
Yes, my lord. But he has made threats of utilizing his power and connections to force a.
No, we will not serve the copy and come back. Sorry, we can't grant you
My
injunction.
lord, at least on the injunction 8, which is restraint,
Serving.
my lord, allowing me to interact with my son, at least till such time as the appeal is right. She's restraining me from meeting my son.
The Guardians and Wards Act, go there and make applications. By way of an interim order, this will be granted. Service 1 week after which. Yes, next.
Behalf of the appellant petitioner, my lord.
Yes.
It's a matrimonial suit initiated by husband. The
Why you beg again?
Oh, my lord, I'm sorry. My mistake. Here, my lord, your lordship formally admitted the appeal and you have directed me to serve. The service complete. Directly to check. 9th of December, this has been served. May I come back on Monday? Only 9th it has been served. Active in town. Great.
Not today.
Yes, my lord, I appear on behalf of the petitioner, my lord. Wife, lord, matrimonial dispute, my lord, the suit has been filed in Tamluk. My lord,
I have already served the affidavit. I am for the affidavit, my lord.
Have you served?
Yes, I have served. Is the supplementary
This
affidavit
postal article is returned with what remarks?
refused?
All?
At intimation unclaimed, some of refused,
Yes.
refused, my lord. You mentioning affidavit, mention, after mention, after mention. Extension of interim order. Extension of interim order.
Nobody lives here. It is.
See the extension of interim.
Something. First person, the surface. Oh. Something is not connected. No such person. There are many who could not, whose whereabouts could not be located. It says nobody lives at that address.
My lord, the fact is that they are intentionally just doing that all this. My lord, the fact is it is the partition suit where the suit has been filed by the appellant before the learned second civil judge Baripur. So and my lord, the fact is the learned court below was pleased to reject the matter as there is no grounds of urgency. On the ground, there is no urgency on the
Injunction application
Yes,
rejected
my lord, exactly.
on the ground of urgency.
Urgency, my lord. Then it has been appeared before the Honorable High Court, my lord, where the Honorable High Court presided over by the Honorable Justice I.P. Mukherjee is pleased to extend the pleased to pass the interim order, my lord, and which has been extended from time to time. The fact is that the petition appellant herein, appellants and the private respondents are the joint owners, joint co-owners of a subject property, my lord, and the subject property which has come inherently. My lord, now without by suppressing the facts, my lord, the private respondent has made the illegal
Private respondent.
Private respondent, my lord, the
They are all
respondent.
private respondents.
Yes, my lord.
They are parties.
Respondent made the illegal construction over the property, over the portion of the plaintiffs, my lord. My lord, here is the appellant.
How can you say the portion? Because it is a joint property.
My lord,
Everybody has the right in every inch of the
but
property.
yes, no medicine, no partition suit was still pending. No medicine bound has been made by the both the parties, my lord. And then, my lord, they are already sold out some of their portions of the appellant hearing to some the third party, my lord. Now the third parties again filed several claims, several title suit against the appellants, my lord, in the learned court below. And
What for?
Because subject property on the basis of the subject property of the title suit and the subject property of the appeal is the same, on the basis of that ground that the petitioner appellant hearing, they are just under they are disturbing the private respondent. The fact is that, madam, the respondents have respondent has sold out the portion of the property.
But they are the co-sharer. You have filed this suit for partition.
Yes, madam.
The moment you filed a suit for partition
Yes.
against the defendants, the first and foremost thing is that you admitted that they are the co-sharer or co-owners of the property.
Yes, they are.
First admission comes that they are the co-sharer or co-owner. Otherwise, they will not be pleaded as a party in a partition suit.
It has been admitted, madam.
Correct. The moment it is admitted, one of the co-sharer has a right to sell his property. Can there be any law which put a fetter? No, they can.
My lord,
They can sell their share. No, you are. They can sell their share. Just wait. They can sell their share.
my lord, it has already admitted the suit is pending, and until
Transferee
unless the
pendente.
decision has been made.
Yeah, the transferee pendente. Ultimately, if the suit for partition is decreed in the final form, whatever is allotted to their vendor, that will be binding on them. They can't say anything more. They will be bound by that.
That is why we have filed for addition of parties, my lord. This is the main ground.
So addition is a different. Addition is allowed or not allowed?
Addition, we have filed before your lordship for the addition of the party, my lord. Now it is
That
up to the-
application, when the transfer was affected,
long ago, my lord, transformers.
why you did not bring them
That
before
was
the
not
trial
within our
court?
knowledge, my
Why
lord.
you did not bring them before the trial court?
That was not within our knowledge. Instead, they have they have filed many suit against us and served us before some days, madam. Many title suit against us and served us before some days, madam. Now I want the addition of party as because the subject matter is same, madam. This is the main reason we want to add the party. madam.
Do one thing. These respondents, how many have gone there and filed? These added respondents, proposed added respondents have filed a suit.
Yes, madam.
The present respondents have not filed any suit.
No, madam.
They
No.
did not.
No.
Did they appear in the trial court?
Yes, madam.
Can you serve the notice upon them, the advocate on record of the respondents, that this matter would be taken up on Tuesday? Which district?
My lord, they have already appeared before some days ago, my lord, when we have taken the adjournment. They have already been appeared.
Who?
My lord, it has been-
What is the name of the advocate? What is the name of that advocate?
Yes. Rahul Kumar Singh, my lord.
Yes,
Rahul Kumar Singh.
advocate
Yes, advocate.
for the respondents.
Yes, my lord.
Can you give him a notice? Rahul Kumar
That
Singh.
day, that day he was present, my lord, and I just taken the adjourn before him. And if your lordship direct, then I will give the notice again. ma'am.
Serve a notice indicating that this, can you serve it today? Where is his address? High Court. Oh, this is Calcutta 26. Do it in course of this weekend. We are fixing this matter on Tuesday. The affidavit of service filed today reveals that several respondents refused to accept the copy of the instant applications, and the others could not be served as their whereabouts could not be located by the postal bureau. We are given to understand that on the last occasion they were represented by Mr. Rahul Kumar Singh, the practicing advocate of this court. So, in view of the above, now, since there is no appearance on behalf of the respondents, we feel that another opportunity should be given to them to appear in the instant matter. So stop. Accordingly, the advocate and record of the appellant is directed to serve a notice upon Mr. Rahul Kumar Singh, the practicing advocate of this court. Indicating that this matter would be listed on Tuesday. Yes.
My lord, in this matter, for the respondent opposite party, my lord, I'm praying not today only because my lord.
But this is really a restoration application. You are opposing?
No, I'm not.
Who is? Where is Mr. Parthasarthi Das?
I cannot say, my lord.
He is not serious. His matter is dismissed for default, and he is not serious in the application.
Only not today because my lord dismissed.
Not today.
Pardon.
My lord, I'm appearing for the appellant. I'm appearing for the appellant led by Mr. Oyan Banerjee. My lord, there are 4 applications. One is an application for injunction. Can 2 is an application for recalling the order by which the matter was dismissed for default, your lordship. Can 3 is an application for condonation of delay in connection with Can 2.
When the matter was dismissed.
Your lordship, the matter was dismissed on 26 September 2019, your lordship, page 10 of Can 2, your lordship.
Have you served?
Lordship, yes, I have served.
Condonation and restoration, have you served?
Yes, your lordship. Your lordship, I would be amiss if I didn't inform your lordship. After mentioning the matter, I sent a notice to them, although that's not been served yet.
Show us on Monday, if it in the meantime it has.
Lordship.
Please call the next.
Your lordship, should I take back the affidavits of service? Or they'll stay?
Take it back.
Lordship.
Hi, Malad. I appear for the appellant, Malad. There was direction for service, Malad. It has been sent, Malad. One of the postal endorsement has come back with remark diseased, Malad.
Then
you have to take steps, Malad.
Who?
Respondent number 5.
The affidavit of service filed today reveals that the postal article sent to the respondent number
5
returned with the remark disease. Stop. In view of the above, let this matter go out of this to enable the appellant to take appropriate steps.
Yes, sir. But it's till July.
Yes.
On 18th August, matter appeared before losses. The suit for partition is dismissed. We filed an application for injunction. We serve. But so far as she is concerned, initially we served. This one or 3.
Yes.
But we initially sub copy of the application, they return back. Thereafter, pursuant to the order of this one presided over my IP Mukherjee sub said notice that return back. Now 18th August 2023, the matter appeared before Lordship and also Ajay Kumar Gupta. That since the response number 4, the name was not according to degree, my leave was granted to correct the record, or to correct the name, but that has been corrected. But so far, there's a direction to serve upon response number 4 again. But I think that to serve, but I could not trace out.
Served.
I could not trace out.
Let the matter go out of list.
No.
The service is not complete.
No, but after a warning, because when I serve.
Come.
No, man. Otherwise, after warning. It's an injunction matter.
What after?
After a week or after vacation, man.
So we are saying go out of list.
No, man. Let it be ready. Well, let it be.
Service is not complete.
Let it be. But otherwise, again I shall mention, my lord. But let it be. Let it remain in the list, my lord. Well, let it remain in the list.
Next.
Yes, my lord.
I'm for the appellant, my lord.
My lord, I am for the respondent number 1, 2, and 3. My lord, I have filed an application for modification. Can 3. Lordship, my learned friend filed affidavit in opposition, and I am filing my affidavit in reply. Lordship, kindly take it up, my application at first. My lord, they also filed another application for extension of time, Lordship. Kindly take my
Is
application.
this application for clarification of an order?
Kindly comes at page. Lordship, kindly comes at page 14 of my application. This is a Lordship order.
Can 3.
Lordship, there is a direction upon the state to deposit. It kindly comes at page 14 of your Lordship's order, Lordship.
First, let us find out can 3.
Yes. At
Where
page
is
14.
the order?
At page 14, Lordship.
Yes.
Property portion.
What
Lordship,
it says?
there is a direction, Lordship, 1, 2, 3. Third paragraph in the middle, Lordship. According to the respondent, the total amount as on 31st July 2023 stands at rupees 2 crores and odd, out of which a sum of rupees 80 lakhs and odd has been paid to the respondents. The balance amount is required to be deposited by the appellant as a condition precedent for stay of execution proceeding. Thereafter, Lordship, they were directed, there is a direction upon the state to deposit 1 crore and odd. Lordship, kindly comes at page, Lordship, there is a direction upon the state respondent relying upon the breakup filed by me. Kindly comes at page 16. That is the breakup. I have filed on that particular date, Lordship. Kindly comes at page 16, annexure Y.
Correct. So we have recorded 2 crore 31 lakh 60,000.
I am coming, Lordship.
So that is what your breakup is.
I could not assist your Lordship properly. Lordship, kindly
Could
comes
not
at page
assist.
16. Market value of 10.57 acres, 1 crores and odd, as per judgment of the learned trial court, page 16. Collector's award 80 lakhs and odd. Thereafter, point number 3, there is a deduction, Lordship. Lordship, there is a deduction from market value and award amount. Lordship, there is an enhancement 60 lakhs and odd. Then my calculation starts. Ultimate 2 crores and odd, it stands 2 crores and odd. Total amount would be, after deduction of 80 lakhs and odd, Lordship, further deduction of 80 lakhs is not necessary. Well, I could not assist your Lordship properly. This is my humble submission, Lordship.
If you have received the payment of 80 lakhs,
80 lakhs.
then you are not entitled to any interest subsequent thereto.
There is a direction by the trial court. As per judgment of the trial court, I have calculated this amount.
Then the trial court has said that it should come to 1 crore 41 lakhs and odd.
Lordship.
So 80 lakhs and odd has been paid. So 60 lakhs is the there.
Enhanced amount.
So lessium is to be calculated at
Upon
a 30% of the market
value. Yes. And 12% additional interest on the market value. And total
true course and odd it stands, that would be payable payable to my client.
Which one?
True course and odd. Bold, Lordship. True course 31 lakhs 60,000 and odd.
Okay.
In place of 1 crore.
Cannot be, because 12% would be calculated because 80 lakhs has already been paid to you. You can't claim the entire interest at the rate of 12% on 1 crore 41 lakhs.
Lordship, 12% additional interest on market value assessed by the
Correct. So
assessed by
difference
the
is,
landed
the
trial court.
difference is 60 lakhs.
60 lakhs enhanced
So,
amount.
so that is the only way 12% has to be calculated on 60 lakhs.
Lordship, that is the market, total market. Kindly see the judgment.
Madam, the difficulty is
Kindly see the judgment.
difficulty is because you have come to a person who is a science graduate.
It is my lord. Lordship,
Like the market value, the collectors made an award assessing the market value at 80 lakhs.
80 lakhs, collector's award, yes.
It appears from the record that this 80 lakhs have been paid to you.
Lordship.
Now you raise a dispute. Reference under section 18 was made to a LA court. LA court says that no, 80 lakhs what it has been arrived is not correct. It should be 1 crore 41. So the difference amount is the 60 lakhs. That is 60 lakh you are entitled to get. Now, enhanced amount, solatium I can understand it should be on an enhanced market value. It will relate back to the date when the acquisition proceeding was initiated. I appreciate. When you talk about the interest, then the interest must be calculated on definitely on 141. But you have to calculate it because 80 lakhs has already gone to you. You can't include 80 lakhs into an interest component or for the purpose of interest component and claim the interest up to that period, the entire period. That you cannot because you have received the money. You are appropriating that money.
Lordship, kindly see my point number 5. Kindly see point number 5. 12% additional interest on market value from 17th February 2010 till 22nd December 2010. That is from the date of declaration to date of position. Let's say as per direction of the trial court.
Hey, that too is the interest cannot be done in this fashion. We will not accept that because had it been a case that not a single money has been paid to you, I could have understood that. But it appears that the 80 lakhs has already been paid to you.
That is true. 80 lakhs had already been paid to me. But my lord, according to my...
Make a clarification that what you have deposited is correct. It is an excess amount which you have deposited.
My lord, there is
Should have been less.
Oh, no, my lord, there...
Not notice this because on that day they agreed, no difficulty, we will deposit it. Little amount.
They have not
So we
deposited.
did not,
They have not. They have not deposited.
but we noticed that at least 2 crore 31 that was noticed in the order.
Yes, yes.
80 lakhs have been paid, noticed in the order.
Lordship.
The remaining amount we did not go for a veracity. We directed them to deposit. So they have deposited 1 crore 40.
No, Lordship. They have not paid it. Prove that. That is why they filed the application for extension of time.
We have filed an application for extension of time to deposit the amount, my lord.
You file, we are extending filing.
Yes.
1 crore 41.
Yes.
How much time you require?
Within 1 week.
Within 1
It
week.
is ready, my check is ready.
Correct. You come.
Check the correction.
You want a clarification? We can do it. A clarification, we will reduce the amount. Do you want that?
Lordship,
We will calculate.
Lordship, let the lower court record bill call for and kind at the special messenger cost, my lord, let me prepare the paper book, Lordship. Let them deposit, Lordship.
We are coming. Yes. We will dictate.
Yes.
Simply extending the time, let them deposit thereafter. What is your application?
But our application is scan 4, madam.
My lord, I am filing my affidavit in opposition against this because within time they failed to communicate the order to the authorities. After 14 days, lordship, they communicated the order.
An application of the appellant, seeking an extension of time to put it the money as directed by this court on 1st September 2023. One week after. Because of the procedural as well as the approval for the said amounts to not be yours. And therefore the delay in complying the direction passed by this court was unintentional and beyond the control. Though the respondent has opposed the said application, but after considering that the said sum as directed by this court is otherwise ready for deposit with the Registrar General of this court. Come on.
But I am praying only 2 weeks, madam. There are some
No.
correction needs in the madam check, madam.
Whatever,
Check has already been issued.
We therefore extend the time to comply the order dated 1/9/2023 for a period of a week from date. The application is thus disposed of.
If you will.
And 3. So this is an application taken out by the respondent seeking a clarification of an order dated 1st September 2023. Though the opposition has been filed.
But I am filing today, madam.
But we find that the points so raised therein
My lord, in their affidavit in opposition.
to the merit of the instant appeal, and therefore we do not intend to pass any order of clarification at this stage. Therefore, the application is disposed of. However, the point agitated in an application for clarifications are kept open to be decided.
I'm grateful, lordship. Lordship, let the
Otherwise, we say dismiss, then everything will go again.
lordship, let the lower court record be called for. I shall put the petition as their cost.
Lower court record be called for through special messenger at the cost of the respondent. Such cost shall be put in within a week from here.
And after arrival of court
The
record,
examination, service of notice of appeal, the notice of arrival record upon the advocate and record of the respondent. The respondent shall prepare paperwork within 4 weeks from the date of service of arrival. Respondent, prepare. You are in hurry. You are in hurry. Do it.
নাহলে পড়েই থাকবে
Notice of arrival will serve on you. You are in hurry. Do it. Do it. Do it.
They got this stay.
You
They
got-
got this stay in
you got-
execution
you got
case.
More money. Don't worry.
No. I have no money.
Yes, yes.
Under
Yes,
compelling
Lordship.
circumstances, I am making this prayer, Lord.
Let it go out of list for the timing, but this is Millard challenging a preliminary decree of partition. Now, Millard, in the meantime, in the trial court, we have already filed a joint petition, Millard, for Sholanama, Millard, that is pending. Let this matter go out of list, Millard, in the
It is submitted by the counsel for the appellant that
appellants.
appellants that
No, sole appellant.
appellant that the parties have filed an application for compromise before the trial court, which is still pending. In view of the above, let this matter go out of this for the time being with liberty to mention. My lord, item 253, my. But in this matter, my lord, I fairly submit with your lordship, my lord, this matter, your lordship may not be taken up. My lord, this is only one thing, my lord, this matter, though, it is my duty to point it out. But this matter relating to my civil court matter. But no, my lord, only one thing, my lord, this matter only prayer for expeditious disposal.
No. We don't have a determination.
That's
For want of determination.
my lord, only this record may be.
For want of determination, let this matter go out of list.
My lord, the file may be.
We can't say anything.
All right.
We don't have a determination.
All right.
Excluding the civil
All
court.
right. That's why, my lord, it is my duty, my lord.
Thank you.
I thought it was good.
Even if innocuous prayer, but whatever.
Lordship, I'm appearing.
Sir, can one?
Lordship, there was no direction and there was no caveat, Lordship. There was direction.
What is this can one? We are asking you, what is this application can one?
Application for stay of operation of
The judgment and decree. What is the nature of the judgment and decree, sir?
for shoot for specific performance of contract.
Dismiss.
No, Lordship, allowed.
Decreed.
Decreed, Lordship.
Execution levied.
Lordship.
Then you'll have to seek for stay of the execution proceedings.
Lordship, when I have filed this application, there was
no
execution proceeding. On the last occasion, your lordships were pleased to direct me to file a supplementary affidavit.
Correct.
This is the supplementary affidavit, Lordship.
Let the supplementary affidavit filed today be kept on record. This is an this appeal arises from a judgment and decree passed by the trial court by which a suit for specific performance of an agreement for sale of the immovable property is decreed. At the time of filing the instant application, the said decree was not put into execution, but on the day when the application was taken up, it was pointed out that the respondent has put the decree in execution, and a liberty was granted to the appellant to file the supplementary affidavit. So let the supplementary affidavit filed today be kept on record. In view of the fact that if the execution is allowed to be proceeded with and the deed is executed in favor of the respondent decree holder, it would render the instant appeal infructuous or may invite a cumbersome situation in the event the appeal is allowed. In such view of the matter, we feel that there should be stay of further proceedings in the execution case. Accordingly, there shall be stay of all further proceedings in title execution case number 9 of 2022, pending before the court, the second court of Learned Civil Judge Senior Division, Mednipur, for a period of 8 weeks from date or until further order, whichever is earlier. The appellant is directed to serve the copy of the application as well as the supplementary affidavit upon the respondents by speed post and shall file the affidavit service on the returnable date. The application is made returnable after 4 weeks.
Deeply applied.
I beg to appear on behalf of the appellant.
Why you beg, sir?
My lord, in this matter, my lord, I not place this application, my lord, is a wrongly filed, my lord. A stay application, dismiss the money suit, my lord. I'm the sole plaintiff appellant, my lord. Kindly directive.
What application?
My lord, stay of. Okay.
You want to withdraw? The learned advocate appearing for the appellant submits that the learned advocate appearing. Oh, that is item number
255, my lord. Sorry.
55.
Oh, sorry, sorry. Sorry, sir.
ঠিক আছে. He's in hurry. Why you are stopping him? The learned advocate and record of the appellant submits that his client does not intend to press the instant application. In view of the above, the instant application is dismissed as not pressed.
My lord, directive is given to call for the LCR and paper.
FA, call for the records, requisites all within 1 week, special messenger cost within 1 week.
My lord, 2 weeks. My lord is a poor man. My lord is
The poor man.
aged
So
person.
special
My lord.
messenger cost 1 week after reopening, requisites 1 week after reopening, then paper book 4 weeks or 6 weeks from the date of service of notice of arrival. Liberty to mention after the service is effected and paper.
Great.
Your Lordship, I'm for the petitioner. On the last occasion, it was fixed for the service, and
What is
today,
this application, madam?
this is restoration application.
Restoration. Have you served?
Yes, Your Honor. I would like to serve the copy.
Then it was dismissed for default, madam.
No, it was a decree.
Oh, this is the restoration application.
Yes, Sir Lord. Yes.
When the matter was dismissed.
Oh,
for
8th April 2029.
8th.
Sorry, 2019.
When the application is taken out,
It was filed on.
let the affidavit of service filed today be kept on record. Full stop. Despite service, there is no appearance on behalf of the respondent's court. This is an application for restoration of the instant appeal, which was dismissed for default on 8/4/2000. After perusing the amendments made in the instant application and on hearing the counsel appearing therefore, we are satisfied that the petitioner was prevented by a sufficient cause in not appearing on the said actual day. Full stop. Accordingly, the application is allowed. The appeal is restored to its original file number. Yes, next.
Much obliged.
Yes, madam.
My lord, I'm
What
for
is
the
this
respondent.
application? Can 1, can 2?
Well, you lordship remember on the last of
We don't remember anything.
revocation of the
Probate.
will.
Revocation of will never happens. Revocation of probate or letters of administration.
Probate was granted without any citation and you revoke it.
There was no revocation of probate. Say that revocation of will.
No. So, my lord, your lordship remember that
We don't remember.
That's all right.
Remind us.
But the one building has already been. There are simultaneous 2 buildings are there. One has already been demolished, and the other is being
In a process of being demolished.
On the last occasion also, we are not supplement evidence.
Madam, serious
And your
issues are raised.
They wanted
My
time.
lord,
This is the 4th time, 5th time we are coming. Twice they took adjournment, and one of the supplementary evidence was also there. The copy was stopped, but my lord, no order, nothing has been recorded in that way. So my lord, this is your lordship. One thing, I'm sorry, I don't want to remember. There was no citation. They say, all right, we happens to be agents. The court
You
never.
are
Agnates.
Agnes. Court never made any discussion of anything, and neither citation was made. And in Asian age,
What is this application? That is the merit of the appeal.
this is the injunction application. We filed it
For
initially restraining them from transferring, alienating, and all these things.
no difficulty.
Now, by this time, again, when it was demolished, before just vacation, so immediately we made an application filed before Puja vacation,
Injunction not to demolish.
not to demolish, restraining them from, or not to.
Who was appearing?
Mr. Prabal Mukherjee.
Where is
And
he?
your lordship,
My lord, he's indisposed at this moment.
What?
He's indisposed at this
What
moment.
has happened to him?
My lord, he's not in town.
No, this cannot be done like this. He has to come and argue. We have
Yes,
granted
my
the
lord,
time, but Monday is the day when this will be the first matter on Monday.
Absolutely, my lord.
is this supplement is
File it on that day. Let's call the next.
Number 3456.
Is this is a appeal and counter objection? No, civil revision. Both are tagged together.
Legally, there is no court fees below. That matter legal aid.
Legal, it does not mean that you will have a special privilege. The law would remain the same. I am asking you, there are two matters which are tagged. One appears to be FAT, means first appeal.
Yes.
Another is a CO, means civil revision.
Yes.
I just wanted civil revision filed by you. Why civil revision? I just wanted to know.
Civil revision has been filed for non supplying the certificate copy of the decree.
What is the defect, sir? Defect removed. Several orders appears to have been passed. No. What is the defect, sir? Certified copy of the decree of the trial court has not been filed. Where is that?
Subsequently has been filed.
When? There is a deficit court fee of 49,900. Have you put in?
Deficit court fees, I file an application for exemption court fees. Can one?
Under what provision we can grant an exemption? To us. I believe I invited your attention to this. Now I can recapitulate that what transpires on the other day. That simply because the appeal came to be filed through a legal, whatever, the legal services.
Yes, my lord.
Whether the exemption can be done, under what provision? There must be a power to exempt. I just wanted to. Oh, the judge has exempted. Now I remember, the judge exempted in the suit, in the appeal, whether this can be done. I just wanted to know the source of power. There must be a notification. I'm conscious. Where is that? I just wanted to know. I am not aware, but I just wanted to know. Any provision in the Legal Services Authorities Act, any kind of a thing you can show us. Hey, member secretary, registrar যিনি আছে তোমার of Legal Services Authority, Kolkata High Court, উনি mediation এরও আছে, Sharma, Ekota. Member secretary উনি আছেন Mr. Sharma, registrar.
Daku. Strike you legal services. This is. But it must be appointed from the legal services to represent him. Speaking of sir, where it is? The Wakalatnama does not show that it has come through a legal services authority. It does not talk about anything about it. Sir, you are. Sir, show us. Yeah. 30. Let us see where is that section. You have the copy. Last time also we said that this, please bring that where act of Legal Services Authorities Act. Nowadays, this net business is there. Find out. Sir, I believe this is the third or fourth time the matter is called, and we every time we say that show us the provision, you always come with a smiling face, saying that you are engaged through a legal services authority, but of no assistance to us. Find out we are making a Passover, nothing can be done at this stage. You find out, show us that provision, otherwise, then we will examine. Direct the regularization of the AP. Let's call the next matter in the meantime. Let us see.
I'm appearing for the respondent in this matter.
Who is for the appellant?
For the applicant, I'm praying for after vacation.
Why, madam?
Our background record is very sick. He has not come to court today.
Give your name. An accommodation is sought on behalf of the advocate and record who is indisposed. Let this matter be listed after vacation.
Your Lordship, would kindly fix a date because we are suffering because of the pendency of the second appeal, Your Lordship, I'm led by Mr. On
Order 41 Rule 5 does not that you show to the judge. It
Your
never
Lordship-
says that mere filing an appeal tantamounts to stay.
Your
So what
Lordship,
you are suffering, nothing. You can proceed. If there is an execution case, you can proceed. Where is the difficulty? Proceed.
Execution will actually not because of this case will not the project
You
has
show order 41 Rule 5.
that is the judgments of the pendency doesn't amount to stay. No, we have to this is not a case of execution will not
but whatever is there,
our right is not the cloud is cast over our right. So because of this
nothing. Yes.
kindly give a date
1 week after we have said.
1 week after vacation. Much obliged.
Next.
Millard, I beg to appear for the. Did I appear for the Millard appellate lordship?
When I appear for the respondent, my lord, I raise a point of maintainability.
Kindly Millard, cease Millard, your lordship's Millard, order dated Millard 11 July Millard 2023. Order 14 Rule 11 Millard, it was admitted Millard, and today is the date Millard, fixed Millard for hearing of the stay application Millard. Since my ground Millard, kindly seize Millard the order. Kindly seize the order date 11 July lordship.
261. Okay. Yes.
Order dated Millard 11 July Millard 2023 lordship. It is submitted by the learned advocate for the appellant that on the date of filing of the said application and without serving the copy thereof, the trial court proceeded to allow both the applications, namely application for substitution as well as an application for removal of the receiver and appointment of new receiver. In view of the aforesaid submission having advanced, though the same is not reflected in the impugned order, we feel that the presence of the respondent is necessary in this regard. Accordingly, the appeal is formally admitted. The appellant is directed to subcopy of the applications being can number so and can number 2 upon the plaintiff response by speed post, as well as upon learned representing them.
Yes.
But I question the maintainability of the appeal. Possibly, if your lordship takes a look at the applications, this is not an appealable order. May I show your lordship the applications, which were the subject matter of the common order by which 2 applications were allowed. This cannot be possibly, in my humble understanding, subject to your lordship's testing it, is not an appealable order.
My lord, kindly recapitulate, this. Lordship was pleased to direct me. You go for your homework. I'll also be doing my homework. There were 2 things. Lordship may kindly check this live streaming also. As many as 3 hearings took place, my lord, only on the point that whether, why haven't you gone for revisional application, why you are before this FMAT court, lordship. And thereafter, after 3, as many as 3 hearings, my lord, lordships are pleased to admit this matter.
That was done pre-service.
We'll
of
hear
order
out
41.
keeping that
No
point,
caveat.
Yes.
keeping this point open, but we will hear out.
May I prima facie try and satisfy your lordship?
Go on.
Only by taking your lordship to the 2 applications, very small applications. Kindly take a look at, my lord, page 30 once, my lord, that is the first application, 3 That is for substitution of one of the deceased.
One or can do what?
My lord, this should be, my lord,
This is can 1,
Can
stay
one.
application.
can 1 stay application.
Yes. Page.
30, my lord, 30.
Yes.
My lord, this is an application under order 22, rule 3, which your lordship will find, my lord, from page 30.
That's the
Thereafter, if my lord
substitution.
kindly take turns over, my lord, to paragraph 2, your lordship will find that, my lord, the applicant had indicated that which plaintiffs have passed away, leaving behind which of his legal heirs.
Yes.
At paragraph 2. Then, my lord, will kindly come to paragraph 3, that the applicant state that they intend to substitute the names as the legal heirs of the plaintiff.
Really, in effect, a substitution.
Substitution application.
So,
Now, this is one application.
what is the other?
The other application, my lord, will kindly have a look at page 35.
Yes.
That is for renaming the one of the deceased receiver. The receiver had passed away. For renaming the receiver, this application. Kindly see page 35. It's an application under section 151. Though the heading of the application is not relevant, but still I'm just showing that it's a 151 application. Kindly, my lord, then turns over to my lord. Paragraph 7. There are two joint receivers. Paragraph 7 at page 36, bottom. My lord. By an order of 10th of October 1992, was modified by the Honorable High Court, and the standing receiver Sri Nitendra Kumar De was replaced by the Honorable Court. Mr. Amir Hussain Malik being the defendant number 1 and Mr. Akhtar Hussain Malik being the plaintiff number 1 were appointed as jointly party receivers in respect of the suit property. Then that by order dated such and such, the plaintiff was pleased to record the above and directed the joint receivers to take possession. Then the receiver was in custody. Then I'm not troubling your lordship with the other pleadings because that is not possibly germane for the present application. Then my lord will kindly turn over to my lord page 40. Kindly sees the paragraph 15 at the bottom of that page. The petitioner states that though the receiver Mr. Such and such died, but with the death of the receiver, your petitioner may humbly submit that the office of the receivership has not come to an end, and states the receiver has not been removed by any order, and the suit property is still in the aegis of the receiver, and the office of the receiver did not come to an end with the death of the receiver. So the necessary substitution in the name of the personnel. So it's not an application of under section 1, under order 40, rule 1, for any appointment of a receiver. Kindly sees the prayer immediately after paragraph 17. It's in a paragraph form, my lord. In the premises, it is prayed that your honor would be graciously pleased to rename and or replace the receiver in the suit, or else the petitioner would be prejudiced. That is the only sum and substance of the application. My lord, may I take your lordship to the order impugned? There is possibly an incorrect recording in the order impugned, which has been taken advantage of by the appellants here.
Anyhow, we'll hear out. What is this application?
My lord, this application is for me a stay of the operation of the order, lordship. As because
we can fix the date
as
for
because
hearing of
my
the
lord,
appeal.
my lord, may I,
We can
Sir,
fix
my
the
lord, may I
date.
respectfully submit, lordship, because my specific challenge in this my lord misappeal is that this order was passed, my lord, behind the back of the my lord, the petitioner appellants who are my lord different number 2B and 6C of the my lord plaintiff lordship. It's a partition suit, my lord, and so there is violation of principle of natural justice. So on that
Hear
premise,
out,
my lord,
we will fix while a compilation.
My lord, is it your lordship's pleasure that we file an affidavit or a compilation showing the affidavit?
Compilation of
Very-
all the orders
And also I want to place on record the affidavit of service which will show actual service on the.
that whatever in the trial court, whatever you have
Whatever was
done in
there, I will.
compilation, give it to us on the reopening. We'll decide.
Right.
Don't worry.
lordship
The
shall
lordship will kindly
Bring-
keep the point of
Bring
intent.
one more judgment. There are two judgments which have not been brought. One is of Justice Sir Asutosh Mukherjee. Where he has held that the order of appointing receiver is incompetent unless the name is there. It is only after the naming is done, the order becomes complete. It's one, which has been relied upon by a division bench of our High Court Justice Bhaskar Bhattacharya.
my lord, I had handed over all the judgments also on that at the time of admission.
I have seen,
Lordship.
but these two judgments are not here. You have to bring these two judgments as well.
My lord, kindly give us to block the passage. Passengers. This is the original.
ইলেভেনের অর্ডার থেকে সুপ্রিম কোর্ট
When?
as early as possible. The reason being, in violation of the order of subsisting order of injunction and the receiver being there, they have transferred the property. Subsisting order of injunction in the suit, for which, my lord, we are proceeding in contempt, but they have transferred parts of the suit properties. That is why they are now challenging and wanting the receiver to.
Lordship, may I just, my lord, get some protection from this honorable court, Lordship? Lordship, kindly appreciate, my lord, these receivers playing a havoc with our paternal property. Point number one, they have lodged a fire against us. Point number two, Lordship, they have
But
prayed
he's
for.
an officer of the court. If you have any grievance that the receiver has really exceeded his authority, you can go to the.
But, my lord, our challenge is, my lord, challenge is
Will-
before
will
Lordship on
consider-
that premise, my lord.
This is a very dicey question. We wanted to decide it. You are not also well equipped with this. They are also not well equipped with this. I tell you very simple. Question is, as I was discussing with my brother, was whether it is an appointment of a receiver or it is mere replacement of the receiver. There are a gulf of difference between an appointment of the receiver and replacement of the receiver. Under Order 43, Rule 1, it says an appointment of the receiver is an appellable order. Appointment has already been done. It is merely a replacement. That is what we wanted to hear. This is the point. I have not come across a single judgment as of now. I have not. Nor those judgments really talks about this. Because all those judgments which you have given relates to removal of the receiver.
No,
And
Lordship,
all
nomination.
removal. I am giving you that those
Nomination,
references.
my lord, the word nomination used by
Sorry,
in the
it
impeached
is not.
order.
You have given a federal court reports of 1949 which talks about the removal. You have given a Sripati Dotto, that is a ILR 13 Calcutta series, which is a removal. All these judgments relates to this. And therefore, we wanted to take a conscious decision on this. Because this is a point which and you have cited my judgment for what reason I do not know.
To show, my lord, that what will be the remedial, my lord, forum.
Forum.
So, Lordship, we should go back for order 41 stage now, Lordship, again.
No, it's not order 41.
Admission,
The
Lordship.
Order, no.
Pre-admission stage, Lordship.
No. Look at order 41, rule 11. Does it talk about admission? Any word admission is appearing in order 41, rule 11. Tell me.
Lordship.
Nowhere. Order 41, Rule 11 does not talk about admission. The word admission came because of the appellate side rules,
Lordship.
which says admission under Order 41 rule. But have you seen? There is no word admission. It simply says the court, without serving a notice on the other side, may dismiss the appeal, or then he can serve a notice. That's all. Never talks about admission. But the spirit one can gather.
If
So
not
we'll hear out. We will not.
As early as the business of the court permits, but not after the review.
Mr. Banerjee, do you remember that judgment of before Justice Bhaskar Bhattacharya? Argument was advanced by me on a point whether the appeal is competent against an order allowing the application for receiver, but without naming the receiver. And there, do you have that the working was done on full bench judgment of Madras High Court, then several high courts have said otherwise than the Calcutta one. Can you find out? Though the appeal was admitted, as this court feels that the point raised in the instant appeal needs consideration, invites consider, not needs, invites consideration. And no, solely on the point whether it was an appointment of a new receiver or a replacement of the receiver, which whether the same can be termed to be a removal or not. Such point, in our opinion, strikes at the root of the matter and to be decided not only for the purpose of entertaining the instant appeal, but also maintainability of the said appeal. In such view of the matter, we direct the parties to make a compilation of all the relevant papers and documents filed before the trial court, so that this court can conveniently dispose of the appeal finally. In such view of the matter, let this application and the appeal, let the appeal and applications be listed for final disposal on. Tell us the date. That we will realize. Can we fix it on 4th January?
Not
4th January 2020.
Milord, I'm told me there's a condonation section 5 application also in this matter.
Nothing.
Lordship.
Now, we have been served where there's an application under section 5. There are two cans, can 1 and can 2.
Can 1 is, Milord, the stay application which your Lordship, Milord, has been dealing with. But there I find there is a delay, Milord, there is a section 5 application also, that is can, Milord, 2.
Anyhow, we have directed appeal and everything to be listed together.
There's a delay of around 100 days.
Different.
Lordship 262, I'm there for the respondent lordship. I'm there for the respondent lordship. On last two occasions, they also paid, they have paid for time lordship. Not today lordship, they paid full lordship.
My lord, Lord, I put the appellant.
And
My lord, application for stay of the order number 5, stay of the operation of the order number 5, which is 27 July 2023.
what is that? Order number 5.
Lord, I have annexed to the memorandum of appeal.
What is that?
My lord, in a partition suit, my lord, partition suit was disposed of in a
Injunction
injunction
not to create any third party
interest in a miscellaneous case.
Miscellaneous case originated from
Final degree proceedings of a partition suit.
miscellaneous case means what? Execution.
Order 9, Rule 13.
Order 9 Rule 13.
Filed by the defendant after disposal of the final degree suit.
Obviously, it is after the decree Order 9 Rule 13 will lie. Otherwise, it will not lie.
But the preliminary decree not challenged.
Yes.
Preliminary decree not challenged by the defendant.
Definitely, they have accepted the share, but they do not agree with the allotment.
They did not file any objections.
Which one?
Against the final.
If it is the next party, then the court will say whether the court.
It is not the ex parte. My lord, kindly see the orders. I have
Then
annexed.
why Order 9 Rule 13 if it is not ex parte?
Order Rule 13, court fixed a date for absence of the commissioner's report. They didn't appear up in spite of receipt of the notice.
So,
Notice.
So Order 9 Rule 13 has two limbs.
But
One is non-service of summons. Second is prevented by a sufficient cause on the day when the suit is decreed. So they are coming under the second part.
During the pendency of the Section 5 application, not yet been heard and disposed of as in injunction.
What section?
Section 5 of the Limitation Act.
Yes.
It has been kept pending, not yet been disposed of, heard. And Order Rule 13 summons has not yet been served. Section 5 not been heard. Injunction order they obtained. I put the requisite stamp paper.
I do not find that the application is pending.
Lord, I have annexed all those applications, and my learned adversary cannot deny that the Section 5 is not pending. Lord, I have annexed it.
My lord, this appeal is coming up from 151 application. This appeal is coming up from 151 application.
So what? Nomenclature is immaterial. If the substance is the injunction, then
Page 144, that is the objection against the.
Is it true that the Section 5 is applicable with the pending?
My lord, Section 5 application.
Then how can a court pass an order unless the condonation is done?
My lord, actually, my lord, I'm just briefed yesterday, my lord. But from record, I can see that, my lord, final order, my lord, the court.
I am simply asking you a very simple question he has raised. Section 5 is pending. Pending Section 5, can an injunction be granted?
Yes, my lord, but whether it has been disposed of or not, I'm not.
I have annexed
Section 5.
Section 5.
Not even disposed.
Because in the
filed, immediately filed with Section 5, application injunction, hard ordered.
They have filed their objection regarding Section 5.
This is the application, I have annexed it.
Yes.
Where is order number 1, 2, 3, 4? Where is the order?
Well, 913, page 90.
Yes.
And Section 5 is page 102, annexure N.
I am asking, we don't know by earlier order of order number 2, 3, 4.
Malak,
the Section 5 might have been allowed.
No. Malak, kindly record my submission, not allowed.
He says, I do not know whether it has been allowed or not. Section 5, he admits there is, but he cannot say whether it is allowed
Not
or
allowed. Notice was not served upon us.
Sorry?
Nothing.
Do not know. Sometimes I have seen the order ex parte Section 5 allowed. What you will say?
Well, I have written objection immediately after entering appearance against Section 5 application. I have annexed it.
Where is the order number 1, 2, 3, 4? I am asking you.
Order number 1, 2, 3, 4, right now.
Do
Because miscellaneous case cannot be said to be registered unless section 5 is being allowed. Section 5 not yet been considered.
This notion has gone. This concept of registration has gone.
The section 5 was not hard and considered.
Don't say that. Not registered. It is registered. That's why we, after allowing, we say formally registered. It is registered.
Not immediately after.
Third, section 5 not
Yes,
allowed.
Section 5 is not allowed. my lord.
Then
I'm
how
going
can
to-
injunction?
my lord,
Tell us.
Just going to the previous orders, my lord.
Tell us.
My lord, it is not allowed.
Then how can a court grant an injunction pending section 5? Just tell me.
দিয়ে দাও, দর্শককে দেখাও।
My lord, may I show the orders, but it is marked, my lord.
It's all right. When you say it has not been,
I have just gone through it.
then the question is whether injunction can be granted pending section 5. I am just asking. That's the only point.
My lord.
If you borrow the inspiration from Order 41, Rule 3, capital A, sub rule 3 or 5, though applicable to an appeal, inspiration, then it says you can't.
My lord, it is there, section 5 is not.
Even the date of hearing was not fixed.
Though it is not applicable to other.
এটা অন্য একটা আর্টিকেল সুট। আর্টিকেল সুট তো theoretically point mention.
Yes, sir.
My lord, it is pending, section 5 application is pending.
Tell us. Is it a law or it is not a correct law? We wanted to know from you.
It's not proper. It's true, my lord.
But this is a very innocuous
But my
order.
lord,
Third party interests.
Executive stamp paper.
Are you going to sell it?
Mutation already effected on the basis of final degree.
Sorry, that is
Final
a
degree
different-
gone up.
Sir, the only thing is that you were injuncted from creating a third party interest, means you can't sell it out. That is there. Now, immutation done. Order 9 Rule 13 allowed.
May I?
What for section 144 of the Code of Civil Procedure is introduced in the statute book. Because of this notion.
Allotment was given by the partition commissioner.
Really?
Excess of the share the defendant got.
Are you not realizing he has gone for a setting aside of the decree, ex parte decree?
No, it is not the expired degree. My lord. Partition degree kindly say the order I have annexed it.
Really?
Disposed of in final form. Plaintiff defendant got his allotment, plaintiff got his allotment.
I am thankful that my predecessors or the seniors have gone abroad, have gone to the heaven. Had they be here, they would have.
2/3, 1/3. He got his allotment satisfactorily without raising any objection. But the partition commissioner did. Partition commissioner allotted more than his share.
Going with a closed mind, exporting degree is the exporting degree. Generally, if the term that is on is him, it could not appear on the day when the final degree was marked. And he was come under the say
And
that I was ready for a submission for the court is satisfied that yes, he was.
Lord, I will not be given any opportunity.
Whether the court powerless to
I'll-
say that no, that is their education there, everything has been done, so I will not succeed.
But I will not be given a chance to contest the applications.
What is given, say, you will get an opportunity.
6 months by notice was not served.
And my lord, that is already mentioned in the impugned order also, that the evidence regarding this. It is not that he won't get
Till
chance to
disposal of the
contest
miscellaneous case. Is the order.
because it is admitted fact that on 2 consecutive occasions we have failed to appear when the final decree was passed. So how can this is not an expiry decree?
Kindly see the contents of.
Question to myself, madam. This is my
But you are pretending that.
If I say that I am prevented from appearing. I am prevented from appearing at the time of hearing. But they are well aware of the proceedings. They willfully they didn't appear.
that is for
Court served notice.
Petition is
Court
allowed.
served notice upon them. Unnecessarily, I have been injuncted, my lord. Unnecessarily. Ordinance Rule 13, 2 limbs. Whether the summons was not properly served or not, prevented by appearing at the time of hearing. I have to frame a sufficient cause. That is not the expertise. Kindly see the orders. I have annexed it. Yeah, notice received.
Did not appear. Then what is the second name of ordinance?
Code.
The first name was sufficient. That is the summons have been served, matter ends. You have a notice, don't care. If you do not appear, do not appear. Then why legislature incorporated the second name? Prevented by a sufficient cause, for the reason that even if you have a notice, even
But
if you have served the
but the
on the day when this
but
notice
the cause frame.
he is coming to the court to attend upon an accident. He is aware, he is going to the court upon an accident and hospitalized.
That is good cause.
And then
That is good
he
cause.
is aware, then you say, he
That is
aware.
cause is good.
At this stage, what is the right is fine. Not on my 13. You may presume everything in your favor.
But the
Ultimately, what is the message?
I have annexed the 913 applications. I have annexed the 913 applications. Sufficient was framed by the defendant, not at all good and sufficient. I have annexed the entire order sheets. You kindly see the conduct of the other side.
My lord, the court has stated. But my lord, the prayer, but my lord, it's a partition suit, and my lord, the prayer is innocuous, my lord, to only to restrain the third party interest. No, my lord, that is also my submission, my lord.
What is the surplus?
Finding has to be done. Yes, that. Not by efficient, but by the legal. Yeah.
Rajat, next date is,
No date.
there is a 5th September, it is here, but I guess what is the date for this?
I go to the bus.
My lord, my lord, I mean, my lord, the date was fixed when, my lord,
Not that, what a position you have not.
no, it's not.
I have. You share your.
More
My
than
lord, regarding the commissioner's report, I didn't get opportunity to contradict that, my lord. That was fixed on that particular date. Oh, my lord, my lord.
First, that portion, I just wanted.
My lord,
1143 square feet. 833. I am 2/3, 1/3. 1/3. My lord, kindly says 81 page. 1143 occupies entire first floor roof. My lord, kindly see the conduct of the commissioner. Commissioner, I am in charge 2/3. You get ground floor. And he is in charge of 1/3, and we will get entire first floor and roof. What is the report? I do not know. But I accepted. Well, I accepted the report. Dispose of the matter. But kindly see page 81 for a moment. Yes, Mala, kindly see, he cannot deny it. Entire first floor roof, 1143 square feet.
the defendant being 1/3, I have said no, no need to raise any objection because he is my elder brother. And 2/3, I got only entire ground floor. Because of my marriage of my two sisters, I am candidly confessing. Marriage of my two sisters, I have to mix up Felicia's husband because my husband is unemployed. My husband is unemployed, having no source of income. Two married daughters, two daughters to be given marriage. Well, I have no source of income. I am candidly confessing. And being an elder brother, what is being my lord?
My lord, here from my lord, whatever I have, it is 5th September, I can see, but I guess there's a next date, but I have to take instruction for that.
I'm giving concession to my elder brother. Yes, you enjoy 1 month, 43 square. Okay.
My lord, let me take instruction. But
I will leave it to your lordship, lordship.
my lord, he is concerned.
Well, Monday top, my lord. Give some papers to this application. There'll be order for 2 days. Thank you.
I 65, my lord. I'm appearing on behalf of the respondent. I'm led by Mr. Ujjal Rai, my lord.
For the appellant. My lord, my plaint has been, my lord, partition suit, my plaint has been order 7 rule 11.
Oh, it's a partition suit, not a matrimonial.
My lord, Mr. Rai is on
between brother and sister.
My lord, relatives, my lord.
Brother and sister, two names are there. That's why I'm saying two parties.
Lord, Mr. Rai is on leg at courtroom number 11, my lord. I'm only praying, my lord, praying for not to.
What Roy?
Ujjal Rai, my lord.
Let him come.
Restoration application, my lord. Dismiss.
Restoration.
Can one is
kindly passes it over, Lord.
Restoration. Are you advocate and record of the respondent?
No, my
Who
lord.
is?
Mr. Ujjal Rai, my lord.
Then call him. Restoration we don't keep. When it was dismissed for default?
2nd December 2021. Fine.
What is the ground?
My lord, paragraph 6 and 7 I've stated, my lord. My lord, we are elderly people, my lord, residing in Darjeeling, my lord. Due to miscommunication between me and my advocate, all this happened, my lord. Advocate did not inform her.
The same advocate and record?
No, my lord. There's a change in the
For the purpose of restoration, change?
entire brief is same. Entire matter has been changed, has been obtained, my lord.
Who was the erstwhile advocate?
My lord, Aneshwari Kumai.
Huh?
Aneshwari Kumai.
Where is she?
You have to ascertain, my lord.
Secure. Give a notice to her and secure her presence.
Yes. Kindly, my lord, if your lordship kindly sees paragraph 6. There is no allegation against the advocate, my lord, per se, my lord.
You are
Lordship kindly
saying that
see.
she has not communicated or something. You have
Well, paragraph 6, my lord, I have stated, my lord.
That's a dereliction in discharge of the duty. You have said that during the pandemic, she said that it will not likely to be taken up and assured that steps shall be taken for inclusion and the situation will become normal. And thereafter, this restoration.
My lord, the main advocate who has filed this appeal is Mr. Devashish Mukhopadhyay.
Yes. Who has filed the Waratnama? Devashish Mukhopadhyay.
Initially, my lord, yes.
So where is he? Where is he? We'll have to bring him.
I give notice.
Bring him. Keep this matter on Tuesday. Bring him. Otherwise, we'll not do that. Tuesday. For the next.
Hello, I am for the appellant, my lord. This is section 5 application, my lord. Service not completed, my lord. Service not completed, means section 5 application.
Service not complete.
No.
Service is not complete.
Hmm.
List the matter after vacation, Christmas vacation.
1 week after vacation, my lord.
After Christmas vacation. Yes. Next, 67. 267.
Yeah.
What is this?
This is my application, my lord, for praying for alimony pendentility in connection with the matrimonial suit, my lord.
How much was granted to you?
My lord, I am opposing this, my lord.
The trial court, my lord, nothing, my lord, we did not file any application.
You did not. How much you expect?
My prayer, my lord, is, my lord, 35,000, and there is a minor child also. And, my lord, I have also demanded, my lord, for litigation cost.
How much per month?
Yes, 35,000 for the lady, 25,000, my lord, for the maintenance of the minor.
So 60,000.
And, my lord, I have also paid for, my lord, litigation cost.
How much?
1 lakh. 1 lakh.
Can you submit the memo of appearances submitted by the council?
Now, my lord, zero, running in zero.
No.
Negative.
But that must have been raised because you are liable to pay. Where is that memo of appearance submitted by the council?
My lord, now,
Lawyer?
after, my lord, month of May, there is not a single farthing paid.
No, that is a different issue. But litigation cost we will give you. Give us the memo. How much the lawyer charges for appearance? Give us that memo. We will give you actual. Don't worry.
Let us,
My lord, there are facts to be brought, my lord, and kindly, my lord, I'll, my lord, pray for an affidavit, my lord.
How much is the income
My
of the
lord,
husband?
they have never filed, my lord, the disclosure.
What is the
My lord, no
income?
application was filed, my lord.
Yes.
Business.
My lord, no application was ever filed, my lord.
So, according to Rajneesh versus Neha,
Affidavit of assets.
affidavit of assets and liabilities you file.
My lord.
Both of you.
The problem is kindly grant some ad hoc. Problem is, my lord, kindly see, my lord.
We will consider it.
No, my lord, kindly appreciate. The CSC has given disconnection notice.
My lord, disconnection notice, my lord. My lord, kindly sees, my lord. My lord,
month
My
also.
lord, disconnection
My
notice,
total-
my lord, would be
my
given
lord,
to anyone who does not, my lord, willingly pay.
Yes.
My lord,
Who
it has
is
to
paying?
be, it has to be, my lord, see, my lord.
Saying, my lord, in the, my lord, flat of the, my lord, husband. Now, my lord, he is neither paying, my lord, maintenance charges, not.
My lord, my lord, entire documents, my lord, I have with me, my lord. My lord,
What? Have you paid?
certainly, my lord.
So you pay, give him that, he will pay
I
the
have the bank documents, my lord, till May, in some months.
pay, give him, he will pay the electricity charges. No
Yes,
difficulty.
yes, certainly.
No,
That's all.
electricity bill is the name of the husband's flat.
Throughout this period, my lord, I have paid, my lord.
So you continue pay.
Absolutely,
Because
certainly.
green bill should not
Throughout he
come.
has paid and green bill.
It
there.
should be a blue bill all along, not green bill.
My lord, certainly, my lord. My lord,
And also the maintenance charges of the flat. The secretary, my lord, they are, my lord, housing society.
For the time being, let him pay this charges.
Something, my lord, ad hoc, my lord, because the
will
minor son,
consider.
my lord, education, everything is there.
How much is his earning?
My lord, we do not know.
my lord, no
My lord,
application was ever filed, my lord.
My lord,
First time,
Now she has come. Because
Yes.
you were maintaining,
even
so
not,
she was satisfied. Now you have stopped maintaining. So they have come. He can
my lord,
come,
even
that's all.
towards the son, my lord,
And
he
it
has
is
some
your
social
obligation to
responsibility.
take care of every expenditure.
certainly, my lord. My lord, throughout I have, my lord, done so, my lord. I'll continue doing so, my lord. There's no question of, my lord, not doing my lord, my liability.
Come, we will take up this matter on Monday. Come with the concrete one that where your son studies.
I've given it. I've
And-
given it. Annex all the documents.
And come, we will,
My lord,
we
my
will
lord,
direct him to pay.
My lord, my lord, kindly takes it up on Friday, my lord. My lord,
No,
my lord, I'll just,
Monday.
my lord, I'll
Monday
just
itself.
indicate, my lord,
Monday
my lord,
itself.
some fact,
My
my lord, some
learned friend of
document,
the last
my lord,
one,
some
and also
documents,
we are paid for it.
We are
This is the
concerned
second time.
on,
not
This
for
is
the,
the second time.
not,
On Monday.
my lord,
itself.
not on this ground, my lord.
we are
No, of course,
concerned,
not on
please
this ground,
listen.
my lord,
We are not going to decide the application for maintenance finally.
my lord.
Both of you have to file an affidavit in terms of the Supreme Court judgment in Rajneesh versus Neha. But for an ad hoc, we will see that at least the stay should be comfortable and without any hassles. You should continue paying this electricity charges. You should continue paying the maintenance charges of the society.
Certainly.
Otherwise, the society may disrupt the facilities and the amenities to her.
My lord. Great.
So we'll take care of that on Monday.
Certainly.